Hypocrisy.
Hey, what's up, guys? Welcome to Law-Splaining the Interwebs. I am your host, Nick Rekieta of Rekieta Law, a small law firm in central Minnesota. That is where I'm from. It does not necessarily mean that it's still open. It just means that's where I'm from. Just in case you're the Ethics Commission and you don't understand basic English, and you may be watching this video, maybe because it was reported to you by one breathless woman named Arthur Rapinoe. Who knows? Hey, what's up, guys? How are we doing tonight? I hope you're doing very, very well. I have been a busy lad the past couple days. I apologize. I've had to do a significant amount of driving. I've also had to do a significant amount of research for funsies. Oh my gosh, life is constantly ridiculous. I think that's how it's supposed to be, though. Ann Piccolo says your new wheels. No, I mean, I have been driving my new wheels. That is correct. Yes. But my daughter had camp this week, so I had to drive her up to camp, pick her up from camp. We had a couple other things going on. Speaking of, and so we go pick this little girl up from camp. And it's like an hour away. But Lady Raggets and I also needed to go to St. Cloud, which is like an hour. This shirt is from like 1971. Look at this collar. I could take off if I run fast enough. Oh my God. We had to go to St. Cloud. So camp's like an hour away. St. Cloud is an hour from camp and an hour from my house. So it's like a triangle of hours, right? That we had to drive. But we have an event coming up soon. Lady Rackets is short, so she needs to have a dress hemmed. So you got to take it to the hemmer. I think that's what I call her. I think that's her official title. You got to take it to the hemmer. And so we're in St. Cloud. We had a couple other errands to run there too. Not that important. We decided to go to this one restaurant that my family really likes called Fuji, which is it's a teppanyaki place, commonly called hibachi incorrectly by Americans. It's teppanyaki where they cook at your table, right? They say like a bunch of Japanese stuff, even though they're all Mexicans. Everybody who works there is like either Mexican or Filipino. And they're like, oh, we speak Japanese. And they they do what? I just got a wild text message. Anyway, so they do the cooking at your table thing. So it's myself, it's Lady Rackets, and our little youngest girl. And we're taking her for a special meal, right? And I'm just telling this story to fill in time because there's no announcement for this show or anything today. I've been behind on everything, so I'm letting people filter in a little bit. I assume it's going to be a low attended show because I've been very inconsistent lately. I'm a bad person. So anyway, so we go and it's us three, and seated at the table is a young African American couple, a strapping young lad and a young lady wearing a headscarf, which is common around these parts. So that's not too alarming. Yeah. This all boils down to one punchline. Okay, so everybody orders their food, and my man over there orders the filet mignon. And they come out and they ask you how you want your meat cooked or whatever. He says, well done. I'm like, all right, bold. Bold to spend the extra money on a filet mignon only to burn it to a fucking crisp. But hey, you do you. You do you. He gets the beef on his plate. And he like prods at it confusedly with a fork. It looked like a Pokemon fighting a Psyduck. He does not know what's going on. He's just in there like, okay. And he grabs the cook right before the guy leaves the table and he says, excuse me, is this fish or beef? My man thought he was ordering a fillet of fish rather than a filet mignon because apparently he doesn't speak French. Lady Raggins and I were dying. We're just sitting there like, it's one of those things where you can't burst out laughing, right? Like you can't do it, but you're like, he thought filet meant fish. Of course he did. That was enough for me right there. Like I was dying from that. But then at the end of the meal, hold on. At the end of the meal, the guy comes by with the bill, as they do, right? And so he gives him a credit card or whatever, and the guy comes back with the second bill where you put in the tip and stuff. And the guy goes, what do I do here? And the guy goes, oh, you fill it out and then you sign it. And the guy says, but I wasn't going to leave a tip. This motherfucker went to a hibachi place where they come to your damn table and cook the food as a show for you. And he wasn't gonna tip. He didn't. He tipped $0. You should have seen the look on the waiter's face. You know, the guy who's been bringing him drinks and like making sure that he had everything he needed. You know, that guy? Like, he was just like, and he's sitting there thinking, because nobody goes to these, you don't go to these places and not tip. Like, even if you don't like tipping, you feel like an ass if you're not going to tip. Because there's like, it's a production. It's not just dinner. It's a little show. Yeah, I've seen this show 10,000 times, so it's not like super impressive. But like, they still do it. They still do it. And I was just like, wow. And he told the guy right to his face, like, no, I wasn't going to tip you guys at all. It's like, it's your fault. You don't know what a filet mignon is, you fucking loser. It's not his fault. You tried to order fish via cow, you dummy. Oh my God. Anyway, that's just a little side story. Nothing too important to it. Like I said, I was just giving out a little story while we wait for people to pop in. So my goal was failed miserably. It was to stream a lot more of this Tyler Robinson hearing that we had. Tyler Robinson's pretrial probable cause hearing. My goal was to stream a lot of it. And I streamed barely any of it. And I've been wrestling with the idea in my head, like, do I try and go back and stream all of this shit again? Like, there's a couple 8-hour days, and then there's a couple shorter, like 4-hour days, 5-star day. No, there's There's fucking 20, still 20 something hours of footage, which is not, it's already been aired. So I've been struggling with this, though, because a bunch of stuff has happened as well. A bunch of stuff has happened in here. So it's like I kind of want to go through at least some of it. But do I do the fifth day today? Do we do the fifth day and then maybe work backwards if we get some time? I'm telling you, this is going to trial. I'll warn you right now. This one, if you think that they don't have probable cause here, they already have enough to convict. And this is the problem that various people are having trouble with on Twitter. People who have been listening to people like Candace Owens and Ian Carroll are now stuck in what's called a sunk cost fallacy. For like the past year, these people have been saying things like, oh, he wasn't even at the school. It wasn't him. Blah, there's no confession. Blah, blah, blah. Well, we now know that he was. He was at the school. That happened. He's there. Allegedly, there's some sort of video of him taking the shot. Now, some people are disputing this. They're like, man, no, there isn't. That video doesn't exist. It didn't play in court. They're all just lying, which doesn't make much sense. It doesn't make that much sense. Say what you will about the people involved, whatever. But it doesn't make a ton of sense for Posobiec, for example, who's there, to come out and say, this video played and it clearly shows Tyler Robinson taking the shot. Or you go with the people who are not there, who say that video did not play. Absolutely not. And thus we have our dilemma. We have people who are mixing a couple things together and coming out with a shit sandwich. And the things that they mix together is this: a healthy distrust of government. That one, I'm with you. Government lies. Now, where the government check online tends to come in is public jury trials. That tends to be a check on government lies, because now we have a predictable structure of rules. Now, there are exceptions. We saw corruption in the Karen Reed trial, right? It was naked corruption. We saw what it was, but what it wasn't was manufactured evidence by the Jewish deep state. That's not what it was. What you saw was how corruption worked. Was a judge tipping the scale, just pushing her finger down a little bit in favor of these people that she has connections to, that no one wants to talk about or admit. We saw that. That's what corruption tends to look like. It's subtle. It's quiet. It's not as overt and crazy as people sometimes make it out to be. It's not an exploding Jew microphone made to murder right-wing influencers. It's not that. It's just a finger on the scale in the right spots. Exclude some evidence here, exclude some evidence here, make it really hard, give a hard timeline for the defense here, make this more expensive, et cetera, et cetera, et cetera. Make the defense lawyers fly from across the country for needless hearings that they're having like right now going on. That's the type of stuff you see. That's the type of corruption that is, it's exceedingly damaging. It's really hard to fight against too. So you take your healthy distrust of government, you know, government can lie, government can set people up. And then you mix that with a willingness to entertain all ideas. How do I word this carefully? Not every idea is meritorious. Not every idea deserves your argument, your attention, your effort. In fact, many ideas outright do not merit those things. You should not waste your time addressing every single thing. Someone who's quote unquote just asking questions. I'm just asking questions. All right. But if you don't listen to the answers, then you're just retarded. You're not asking questions at that point. You're yelling with a question mark at the end. That's not the same thing. There's a bunch of people who have, again, spent the past year trying to convince you for some reason that someone other than Tyler Robinson, who is the most likely and very most obvious murderer, that someone other than him did it for some nefarious conspiratorial purpose. Again, it's Jews making exploding microphones. It's a second shooter somewhere with a patsy shooter who is set up in a sniper pad as a patsy shooter for some reason. Like, this is one of the questions you got to ask. So wait, so why is he laying prone with a rifle? Like, why is that happening? If he's not the guy who's shooting, what's he doing there with this? Why is he like, you know what I'm going to do? I'm going to go lay out in the sun with my rifle and I'm going to not shoot Charlie Kirk. That's very important. I'm going to definitely not shoot him. And then someone else, it comes in along and they're like, aha, we got this guy. And they shoot him. They shoot Charlie Kirk and they're like, it was that guy. I saw him. Where is this coming from? Where does this go? Well, as I said, it doesn't go anywhere. It's a sunk cost fallacy at this moment. The sunk cost is, I've said this, or I've listened to this, or I've repeated this for a year, and all the people who are asking questions are unwilling to take on the information that comes as a response to those questions. It makes it very difficult to have an educated conversation about this topic. Because every time you start having a conversation about this topic, someone's like, I thought you were cool, man, but you're not. You're just a fucking grifter. Someone said you're either paid off or blackmailed. It's like, I wish I was paid off. Give me some of those Jewish dollars. My God, I will cover up all the murders for you. I don't even like people. I'll take a Jewish buy-off. You pick a celebrity and I will tell everyone someone else killed him. I don't care. Here we go. See, you have it right here. At least you can admit you're full of shit. Okay. You're right. I did. That's what I said. It's me who's full of shit. All right, let's check out. We got some of these chats early on the show here. Rob Price, 59 months. Wow. Oh, wow. Almost 5 full years. He says, was it the same camp Anne Frank went to? Yes, I'm going to hell, but totally worth it. Oh, my daughter? Yes, yeah, that's right. Actually, she was receiving her Jewish training there, just like Anne Frank did. They're like, here's how you blend in with the rest of the earth. Parasimian, member for 7 months, says, hey, boo. What up, bae? How you doing? Stephanie, member for 6 months, says, I love how much you love your family. They're pretty cool. Don't let them fool you, though. They're all wily. Rita Castillo says, hola, Pinchy Nick. Hola, Rita. Always nice to see you. Miss Peachy Keen, member for 10 months. That member is growing. Wow. Prodigious. People wonder why I say other cultures are shit. It's because they don't know that a filet mignon is a slice of beef. Oh, I think it was the tip thing, though. I think it was just the tip. Let's see. Ms. Douglas says, damn it, you got on without me knowing. Bunch of bullshit. I've been just rambling for 20 minutes. I've been rambling for 20 minutes. You have not missed a single thing except a charming story about a young black couple. And I'm not even talking about me. So I think what we're going to do is we're going to run through day 5 on hyperspeed or whatever. And see what's presented to the court. Canadian Bimbo says you're black only where it matters, which is below the belt and in the credit score. And I think credit scores go by golf rules. Tori Spears, what's good, brother? Hey, what's good with you? I don't know what's good. Only the Lord is good. Actually, I know that. I learned that in school. Let me see. I got to get my Rumble chat pulled up here. We are live on Locals as well. Let's see. Uzelian says today was just more of the defense attacking the DNA like a retard, and instead of attack how it got on there, just attack the DNA itself. That's what I like to do. I like to attack DNA when possible. Dork Girl 21 has rated this stream. Welcome, Dork Girl and her viewers. Why relay is not active? Why are you telling me the relay is not active on Rumble? Rumble's running, right? Am I stupid? I think it is. Is Rumble not on? Is Rumble not on? Oh, no, Rumble is on. There we go. I don't know why that took a second. Why does it say that there's no relay going? Hold on just a second. Wait a minute. I clicked this. I thought. Okay, give me just a second. Sorry. There we go. I mean, not that it doesn't matter to you guys. It only matters to me streaming through Rumble Studio. Yeah, per Dika, I knew I was pulling the chats, but I thought maybe you guys were just having a good time with each other. You're just like, hey, we're just chatting over here, waiting for Nick to start the show. What a retard, he's so late. Okay. DX Mania. Oh my goodness. Kicking us off here. Thank you. DX Mania gifting 10 memberships. Guys. Oh, guys. Oh, I forgot. There is. There's a new one. There's a new cooking with Kurt. Brisket, baby. Brisket. There is a cooking with Kurt brisket edition. It just dropped. It's the hottest thing on the press. That means we are going to have a cooking with Kurt very, very, very soon. Oh my gosh. So, make sure you are here for it. I hear there is a significant amount of heavy breathing that happens. I can't wait. I've not watched it yet. I've only heard the legends and the rumors. That's going to be happening really soon. Really, really soon. I cannot wait. I know this is personal stuff, and then we'll get back into the Charlie Kirk thing. I mean, I guess I cannot wait. Some stuff has happened in regards to some ongoing legal matters, and I can't wait to tell you guys about them. I cannot wait, but I have to wait just a little bit because I can't. The court has this ambiguous and overbroad and ridiculous unconstitutional sequestration order that prevents me from talking about it. But just wait, because that won't last forever. It will not last forever. Oh my gosh. And yeah. There, and I mean, I wish I could tell you what's going on right now. Know this. My constitutional rights are being butt fucked by a judge right now. Right now. Because the judge is just refusing to rule on something really, really important. And this is how they do it, y'all. All they have to do is just never do anything. And you can't really force them. If you try and force a judge to do something, they'll tend to do the opposite thing that you ask for. They'll tend to do the opposite. But, you know, I guess we all just have to wait. Guys, this fiasco of this restraining order has become so funny to me. Like, it's so everything that's happened in it. I want to tell you about it. I don't even like it's so ridiculous. Do you know if I wouldn't have fought it, it would have ended by now? That's how long the judge dragged this out. The judge dragged this out so long that it would have expired on its own. It's amazing. It's amazing. And when I tell you what's been going on now, and here's the funny thing, I know I'm going to get screwed on it also. I'm going to get screwed on the funny thing. But when I tell you about it, you're going to be like, huh. Sucks to be you piece of shit. But at this point, it's comical. It's comical what's going on. And I can't wait to tell you about it. I'm really excited because it's, I don't even know how to describe it. Asia Frazier, member for 77 months. Oh my God. Says, had blue cheese and brisket salad at Cat Cafe, was good. Sounds like something I wouldn't really like myself. I'm not a blue cheese fan. But I'm very, like, I recognize that people like blue cheese. I'm not here to say, like, bad speak blue cheese. It's just not my thing. But I bet it was delicious if you like blue cheese. Sounds good. Even though I don't like blue cheese, it sounds good. MC Cassie G, member for 7 months, says, Nick Ricotta is a groomer. Grooms women. Nick Ricotta. That's a very funny joke every time he says it. Okay. All right. Let's get our Charlie Kirk window here pulled up. And then or Tyler Robinson, I guess. Charlie, I don't even want to say that joke. Charlie isn't saying too much these days, I guess. I don't mean any disrespect on that. It's just true. Fucking hell. Can I just... Oh, I'm going to lose my mind. Go over here. Good job. Good stupid window. Okay. Oh my God, what is going on? What the? Why? Why don't you just... The backspace key wasn't working. Hans One Pack says blue cheese is what a bad yeast infection is called. I hate that a lot. Okay, so day 4 or day 5? What should we do here? I don't even know. I don't even know. I've been going through just I've been just since I've been driving a lot. I've been on Twitter, you know. When I say driving, I'm not always driving. Sometimes I'm riding, for example. Excuse me. But I've been monitoring Twitter. And I think people misunderstand a couple things. People seem to misunderstand what an impartial jury is, or what tainting a jury pool means, who can do it, etc. Some people seem to misunderstand the idea of privacy and who has a right to privacy, who doesn't. So let's start with that one, because that one's easy. It's in the 6th Amendment. You, in the 6th Amendment, have a right to a speedy and public trial. You do not have a right to a private trial. What you can do with any constitutional right is you always have the option to waive a right. All right. So, all right. So if a court wants to have a private trial and you want to waive your right to a public trial, you can do that. But what you cannot do, absolutely do not have a right to convert a public trial that you don't want into a private trial. You don't have the right to do that. This is critical because people seem to misunderstand this. They seem to think that because you have a right to a public trial, that you have a right to a private trial. You don't. There is no right of privacy in trials. So that's the first thing. The interesting thing is Utah itself has a list of victims' rights. And those victims' rights are, I believe, supported by the Utah Constitution, if they're not directly in them. This is a state that specifically grants a series of rights to the victims of criminal acts or their families if they're deceased. And these rights are upheld as equivalent to constitutional rights. Now, remember, the rights that you have from the United States Constitution are the minimum bar that must be provided by all governmental entities, from city council all the way up to the president of the United States and the Supreme Court and all that. So those victims' rights sometimes collide with other things going on, et cetera, et cetera. And, you know, that can cause some friction. But at some point, either the victim's right or the other right will prevail. You only have a conflict of rights when your right butts up against someone else's right. Importantly, it bears repeating, there is no constitutional or otherwise right to a private murder trial. Nope. Nope. The time when your public trial might become private against your wishes, for example, is if the publicity of the trial impacts some other right. For example, if the publicity of the trial impacts the impartiality of a jury pool. We're going to, before you jump on that and go, ha ha, hold on. We're going to talk about it. We're going to walk through all this right now before we turn on the court so that everybody is on the same page, because I've noticed people are not on the same page with this. You have a right to an impartial jury. People seem to think that that means that you have a right to a jury of people with no existing opinion. That is not correct. That is not an impartial jury. Impartial juries, I'll warn you right now, most impartial juries have 12 people with an existing opinion about what's happening, even if they make their mind up the moment they hear the case. They come in with an opinion. The question is not, are they free of any opinion? The question is, are they willing to listen to evidence, find the factual reality, and apply it and submit it to the court, absent undue external influences? Not opinion free and not absent influences, absent undue external influences. People are influenced by everything. You go to the store and you see eggs are on sale, and then you form an opinion about the chicken market or whatever it is. You're probably wrong about it, but you just see eggs on sale and you start to have opinions about different things. We have opinions about everything all the time, and we are influenced by all sorts of things all the time. The question is whether or not those influences are external and undue. If they're just internal, like, hey, I really don't like pedophiles, so I kind of think that this guy might be guilty. But you go, man, I can't believe it. I believe that people who are accused of crimes against children, I believe that they tend to be guilty. But can you listen, accept evidence, and make a decision that is not subject to external influence? Can you do that? Or undue external influence? Can you do that thing? If you can do that thing, you are an impartial juror at that point. You are now part of an impartial jury. The impartiality is not to be free of opinion. And people need to get that through their heads. People like Candace Owens or Ian Carroll right now are vigorously defending their last year of commentary on this case. They're vigorously defending it. And here's one of the things that they're going towards. The idea that sharing video, etc., will taint a jury pool. I've seen a couple people, friends of mine and random people, asking similar questions about tainting a jury pool. I believe it was Nina Infinity who asked me, or who asked basically if, how can they decide that playing this video to the public would be prejudicial, but letting these influencers who are in there talk about it and that not be, like a problem. Okay. And so there seems to be some confusion here about, again, this idea of impartiality. Impartiality does not mean having no opinion, but this is rectified and self-resolving with a simple A-B switch test. If Jack Posobiec, again, I'm picking someone who I know that is present in the courtroom. If Jack Posobiec talks about what he saw in court, and that taints a jury pool because he's swaying them towards one opinion. Similarly, Candace Owens talking about how Tyler Robinson was not present at the school for a year also taints the jury if you follow the same logic. If you follow the same logic, you say someone's opinion can taint a jury, then it actually goes both ways. I don't know if people realize this, but there are multiple, like there's not just one non-impartial, there's not just one partial outcome. The partial outcome of Tyler Robinson is guilty is sure, that's one. But the partial outcome of Tyler Robinson is not guilty is similarly, just in the opposite direction, tainted. Except neither of these positions are tainted. I want to make that clear. Neither one is actually tainted, but people are talking about it as if the people in the courtroom reporting things, because they're influencers, that is somehow tainting a jury pool. But if that's true, then the influencers outside of the courtroom, like Candace Owens and Ian Carroll, have millions and millions of followers and have been saying outright falsehoods for a year, they are similarly to their theory tainting potential jury pools. So this is internally incompatible. It is a concept that does not work when you actually just think through it for a second. That being said, we don't abridge people's right to free speech because it might make impaneling a jury more difficult. It doesn't. It really doesn't. I actually am of the opinion that playing the video wouldn't have anything to do to the jury either, or to a potential jury. I don't think it would taint a jury pool. You got to think about this. This guy was arrested 10 months ago, September 10th or 11th, September 11th, I guess. He was arrested 10 months ago. And every major news outlet has called him the accused Charlie Kirk murderer, the Charlie Kirk assassin, etc. He has been labeled as the man who has assassinated Charlie Kirk the whole time. Showing one video or having commentators talk about a video that they saw in court is not going to taint a jury pool more than that would have already tainted the jury pool. But again, just to reiterate, the jury pool is not tainted just because some people go into a case about a murder with an opinion about the person accused of murder. Every single case people do. They all go in with an opinion about the accused. The question is, can they? And they go through, this is why they go through voir dire, and they're allowed to ask all these jurors a bunch of questions. They're there to suss out who can actually listen and receive evidence, receive facts, and change their opinion or make up their mind at that point. They may have a preconceived opinion, but are they open to change? If they are, impartial. People really misunderstand that phrase and its application. Tim Pool's Gay Music says, good to see you again, Rackets. Hey, I heard you play guitar for your chickens. Critical Salt Theory 208 says, I think Candace Owens should be called as a witness in this trial just so the court can force her to reveal some of these alleged sources. Candace Owens' alleged sources may become relevant in a wrongful death action, a defamation action. There's some other possible civil actions that Candace Owens could be subject to, even if she's not the main party, for example. And, some of those sources might be beaten out of her with a subpoena. We'll see. We'll see. We'll see. We'll see. Dork Girl 21 gifted a subscription over on Rumble, and that was received by Mike Likes Tacos, a very gentlemanly lad, by the way. Mike, I remember you from Vegas. Nice to see you, brother. DX Mania 95 says the video of Charlie's murder went viral within minutes of it happening. It's not feasible to think you'll get a jury of people who haven't seen it. And yet they probably will get a jury of people who haven't seen it. But even if they have seen it, there are people right now who watch that video and definitely believe that Tyler Robinson is not the guy who did it, right? I don't understand why people have this problem. But I guess it's a conceptual thing, and until you're called out on it, you don't really think through it. Right now, Candace Owens believes that Tyler Robinson is not the killer. If Candace Owens lived in Salt Lake City, where on the jury, or were selected for jury duty and showed up, what would she say? Would she say that, she believes he's not guilty? And they would say, Miss Owens, can you listen to a recitation of facts, listen to experts, absorb information, and then maybe even change your mind? Can you do that? And she'd say, yes, of course I can. I always wait for the evidence. And they'd go, ha, you fucking liar. Get out, bitch. And they would strike her immediately because she is a retard. I don't know how else to say it. I'm tired of covering for Candace Down Syndrome Owens, walking around. I shouldn't do that to Down syndrome people. They're way more fun than her. Johnny Deerfist, 3727, member for 12 months, says, I've got a 12-month-long member. That is all. God bless you and your family, good sir. Wow, God has blessed you with quite a substantial member, and I'm very proud of you. Hi. Says, missed you. Look forward to this trial coverage. I don't know that we're going to get a trial on this one. Here's the thing. They're going to find, the judge is going to find probable cause. The judge is going to find probable cause. That's going to happen. Once that's done and this thing is set for trial, they will likely have their plea negotiations. The plea negotiation will be, we'll take the death penalty off the table if you plead guilty and accept a life sentence without the possibility of parole. But right now, as long as probable cause is on the table, if you win probable cause, you win. You win the case. You go home. And they can't do anything to you. They have so much probable cause that it's embarrassing. I don't even know how to describe how much probable cause they have right now. Mr. Miller, 123, member for 7 beautiful months, says, damn you, Nick, how dare you take care of your kids? Did you hear Andrea B. got her article read on Ben Shapiro today? No, that's cool. Andrea Burkhart. Oh, so she's part of the Jewish cabal now, too? I always knew it. I saw a yarmulke under that hair. Just Incredible says, jury deselection was the best law school class. Raggedy Man says, do you think Candace is sincere or guano crazy? I think Candace is, I think Candace is a dumb lady. I mean, she was smart enough to marry a really rich motherfucker, but I think Candace is dumb. And my evidence is this. I saw it. And if you are watching, you saw it too. If you were watching with me, I called it out. It was during the Steven Crowder Daily Wire fiasco. If you guys remember, Steven Crowder was offered an absolute buns contract from the Daily Wire that looked good on the surface, but had so many penalties built into it. He basically would have bankrupted himself while making the Daily Wire a shitload of money. All right. Steven Crowder, he plays hardball in the negotiation. And he ends up not taking the contract, right? Better or worse, I don't know. I don't care. Candace Owens criticized Steven Crowder. And you watched it in real time. She criticized him for being childish and trying to get a different deal than he was offered. And all these other people's contracts came up and like how much money they were making. And you could see it. Candace Owens was like, I went in with my team and we took the first offer they gave us. She realized in real time that she was an idiot and did not negotiate and got completely boned on her contract with the Daily Wire. I called it out on that day. You watched it on her face. You saw her realize that she was indeed the retard. You saw it live. And I said, oh, she's not going to work for them much longer. Because she realized that she got screwed. She thought she was the bad bitch, smartest chick in the room. And all the Jews had already outmaneuvered her. You think she hates Israel because of any other reason than how much money Ben Shapiro and that other Jew who runs the Daily Wire? Like, I don't care about them being Jews, but she does. She fucking hates the Jews ever since that. That's when she started hating Israel and the Jews. It was when she realized that she got boned on her contract in real time. She's sitting here calling other people dumb. It's like, you dumb bitch, you didn't negotiate a thing. You just took the money that they offered you. You're not making anything. Oh, God. It was so great. Oh boy. Watching that was one of the funniest things ever. But that's how I know Candace Owens is dumb. She's a fucking idiot. And she told the world she was. JC Music Man says, good to see you, brother. Check your tips. I'm going to. Thank you for reminding me. Let me pull that up. These are super tips, by the way. I'm going to sign in again. These are super tips. Eventually, I'll get there. These are a way to get your super chat effectively read by an AI voice. For example,
I feel so lost in life right now, and I'm really struggling, need to lose weight, haven't studied for Series 6, taking at the end of the month. I feel like I'm letting my unmedicated depression kick my ass.
Stop. Stop. Stop letting unmedicated depression kick your ass. We all do it. We all do it. We all let it kick our ass from time to time, but knock it the fuck off. Get off your ass, study for your Series 6, and go take it. Go pass your Series 6. Get your fucking financial license and get to work. There's nothing that's going to drag you out of your funk sooner than getting your ass to work and accomplish something. You're sitting around not doing anything. You might as well lay down and die. Don't do that.
Hey Nick, it's Uncle Rico. I'd love to compare notes. I am getting hard R by the whole 5th District, suing the state of Minnesota, the 5th Judicial District, 2 judges, and a court administrator.
Good luck. I remember. I know. You have a long way to go, man. Suing a court and court admin, those guys have so much qualified immunity. You got a lot of work to overcome that.
I hate to break it to you, but the jury gets tainted and becomes less impartial as the evidence is presented. By the time I make a closing argument, the jury is eating out of my hand or the garbage.
Well, yes, that is what happens. But we generally accept that that's what goes on during trial, right? Like that, most people get that. I like this one from Tamara Holloway, member for 22 months. Says Candace Owens just learned thunder is the sound of lightning. She's so fucking dumb. I can't take it. Every time someone's like, yeah, but did you see what Candace Owens said? I'm like, no. I don't care. Even if she's right, I think she's wrong. Okay. All right. Let's see. Wait, that's not a joke? No, stop it. You stop it. That has to be a joke. That can't be real. No. No. That's I don't believe you. By the way, I'm putting the super tip link in the chat for both YouTube and Rumble. I'm pinning those messages. If you guys want to do a super tip for the show, you can certainly do that there. Of course, we also do accept memberships and gifted memberships here on the show. We're going to have a big membership show coming up. I want to say this weekend with the brisket. But okay. So you may want to grab that there. All right. So I was going to do day 5. But day 4 was that was the big bombshell, wasn't it? It's 100% true about the lightning? No. Did someone where can I find this? Where can I find this? Holy shit. I need to know. I need to, is this on a video? Critical Salt Theory says Candace Owens is about to take the Onesian ride. The hole just keeps getting bigger the more she's trying to dig her way out. It's a sunk I called it, I coined a new term. Coined? No, I coined a new term. I call it the sunk cost wallet. Or not the sunk cost, the no true Scotsman wallet. That's what it is, which is a combination of the no true Scotsman fallacy and a wallet. Because that is how conspiracy content works. You have to be on board with everything. You can believe nothing except your own correctness, and you can never stop because the moment you step away, the money goes away. And I mean, I've seen this my entire time on YouTube. There's always been a little flirting with conspiracy theory that happens, and you entertain anything for a moment, and people show up and they contribute. They put money in. They're like, yeah, talk about my thing. Talk about this thing. Talk about that. We're just asking questions. And you sit there and you go, okay, well, this is cool. Like I can entertain this idea for a little bit. You can't. The moment you stop, it's gone. Like it is over, and the temptation will be there to just, oh, no. Well, I mean, why don't we just ask some questions? Why don't we do that? Again, not all questions merit answers. Not all questions merit attention. But yeah, these people who've been making a fortune entertaining these theories and presenting these theories as if they're like worth addressing and discussing. People have tried to get me to engage the Twitter theories or whatever theory you want to call it about Tyler Robinson now. They've been trying to get me to engage that for a hot minute. And I keep saying the one thing, like I'm willing to listen to whatever evidence is presented, but I want it presented in court. I'm not sure because Nestor is running the show, but I have a strong suspicion we are not going to have an exploding Israeli microphone defense. Like, I have a strong suspicion that that's not going to come up from the defense at all. if I had to guess, they're not going to run that theory. I don't think. They might do it. And if they do it, I'm going to lick envelopes on the show or something. But I try to be respectful when people ask me, what about this? What about that? My answer is always, I think you may be surprised or disappointed with what comes into court. And that is all we can, that's the only thing we can assess here. We can only assess what comes into court and what the jury verdict is. We can't, you can never know something all the way. You can always say that the court process was tainted, some evidence was excluded, et cetera, et cetera, et cetera, and they covered up the real responsible party. You can always say stuff like this and always have it have some like level of truth to it. But the thing you can't do is really do much about what comes into court. Like that's how we're going to make the decision on whether or not he's guilty under the law. It doesn't matter what you believe other than that. I don't care. But if you want to know about what's going to come into court and how that's going to play out, I'm guessing like Jewish lasers and microphones are just not going to do it. They're not going to do it. And I've said the whole time, you're going to have an expert come in and explain how there's no exit wound in the bullet. And we learned a lot about that. If you guys are not following Phoenix Ammunition on Twitter, then you're missing out on it, because Phoenix Ammunition put an absolute spanking on Ian Carroll about the bullet and fragmentation today. Yesterday, today, whatever it was, over the past 2 days. He put an absolute fucking clinic on about bullet fragmentation. In fact, though, the more interesting thing was someone retweeted his tweet from last year when the shooting happened, where he predicted exactly what ammunition they were going to find, like what ammunition it looked like. And I'm telling you, like everybody who's been yelling at you about 30-06 and how it always has an exit wound. It doesn't. It doesn't always have an exit wound. There are rounds that are made to specifically bloom out and stay inside. That's what this round did. But don't take my word for it. I don't manufacture ammunition. Phoenix Ammunition does. He knows way more than I do. Jarvis Watch says, wouldn't the jury need to be seated in order to taint it? I mean, where would you put your legs? Around your face, big boy.
Saw the Daily Mail article. I look forward to coverage of the lawsuit. Peace out, Futbucker. Micropeen.
Micropeen. Yes, that is another thing that happened. The Daily Mail attempted to utilize me to attack Marco Rubio, I guess. Which is hilarious. By the way, if that Daily Mail guy, like if you're on here watching, because you said you're a fan of the show, I believe you. Which is why you asked me if I ever covered political content. No, I don't. Only lawsuits. In fact, I've never talked about politics at all. Giant fan of the show. That being said, this fucking retard says that I was honored by Marco Rubio at the State Department. So now I want my hand job, Rubio. I want you put those little hands, small hands, Marco, put them to work. I want to be honored by the Secretary of State. The Daily Mail said it happened, so therefore it must have. He wouldn't have completely misrepresented that at all, would he? That'd be weird if they did that, I think. I I'm just glad I'm as important as I am. That Marco Rubio took the time to personally honor me, like the article says. That probably happened. Critical Salt Theory 208 says, I saw the side view of the shooting. Charlie Kirk wore body armor, and I saw the bulge of his armor catching the round as it exited his back. I don't believe that there is an exit wound, actually, though, on the back. I believe that the bullet remained inside. And again, 30-06 has these lead core rounds. According to Phoenix Ammunition, they're the most popular round sold by, I think, Remington or whatever in 30-06 caliber. And they are fragmenting lead rounds. Like that's what they are. They're not, like high quality Full Metal Jacket, solid copper rounds or anything like that. But again, you got to check him out. Don't take my word for it. I'm just repeating words of someone else. What do we got here? We have Fletcher Boy, very late and gay. Dancer in her soul. Member for 6 months says, I love seeing my membership grow. I love seeing it grow too. It's one of the best things is just sit there and watch it grow. Raggedy Man says the case is overwhelming. Do you think he'll plead guilty? Oh, I thought I talked about this, but I think it's very likely to see. I'm not saying we will, but it's very likely we'll see a guilty plea because they'll probably, again, take the death penalty off the table. And when people are facing their own demise, they tend to make different decisions. When it's, look, if you go to trial, we're going for the death penalty and we'll get it. Because you're a fucking loser. And you just decided to murder the next president of the United States. I mean, he's like our RFK or whatever, right? Charlie Kirk was set on a path towards potentially, very likely being a candidate for the president of the United States. He needed a couple more years, sure. But if not that, Congress, Senate, he had the potential to go to many of these different places. And he was murdered in front of a crowd, in front of his family, and in front of the whole world on TV. That gets you a death penalty. The amount of, I know this sounds gay, and it is, but also the amount of people traumatized by the actions of whoever shot Charlie Kirk is millions of people. Yes, Charlie Kirk is the main victim. His family are the main victims that are alive. But everybody who witnessed that shooting is a victim of the shooter. Every single person. If you're like me and you're a very important influencer who has major news publications writing about his family trips to Washington, D.C., for example, you wonder about, if you get called to speak at a convention or something in front of a room full of people, is someone going to roll up and put a bullet in you? I don't think about that too often because it gets depressing, but it could happen. Absolutely. Charlie Kirk showed us that it could happen really quickly. And, the only thing separating him and some of us is just how fucking important and loved he was. Right? But hey, when you're hated, you start thinking a little bit more about that person who might come to shoot you. Especially when you have fucking weirdos who believe they need to liberate your children from you. Like you start wondering, who's got a gun in their pocket, in their jacket, in their ass crack, whatever, wherever they like it. You start wondering who's walking up to you. Are they going to shake your hand and smile? Are they going to stab you with a knife? Like, you don't know. Everybody who watched Charlie Kirk get shot, everyone I know and talk to about it on the quote unquote influencer level, anyone whose job is social media, we all kind of thought the same thing. Like, holy fuck, this brings it home. This could be one of us getting shot or stabbed or killed. It can happen. Everybody else, may not be in danger of having a speaking engagement in front of hundreds of people, so they're not really worried about getting shot. But they did have to watch someone who carried their ideas, their hopes, their visions for the future, their understanding of America, who carried that on his shoulders for them, the person who was their voice. They saw it snuffed out. They saw their ideas put to the bullet, as it were, right in front of them. And make no mistake, the shooting of Charlie Kirk is political. Absolutely. He was a political target. I'm not saying there's parties involved in all that shit. It doesn't need to be that. But it is politics, and it is terroristic. The idea is if you speak the wrong thing too loudly, you get killed. And there are a bunch of people who are happy about it still. Everyone who watches what happened to Charlie Kirk and the glee that some people had over his murder, every one of those people is a victim of the shooter. Not to the same degree as the Kirk family, obviously. But again, having your ideas, your ethos, your beliefs, your hopes put into a person and have that person snuffed out in front of you just for having the ideas that you have, the ideas that you respect, the ideas that you entertain. Having someone shot and killed in front of you for that, you're a victim too. So this man made victims of millions of people. And believe me, the court sees things that way. Like, I'm not just making that up. The court looks at things in a communal perspective because they're required to. Community safety and security is part of sentencing. There is nothing redeeming about Tyler Robinson at this point. So, okay. What I'm going to do, I guess I'm going to put on day 4 of this thing, because I think this is where most of the bombshells happened. And we're going to play it at 2x speed for now. And we'll just see how we go. How it goes here. I think that'll be a good endeavor for us. I don't know that we're going to get through the whole thing because it's 6 fucking hours almost. And I think that's with most of the breaks taken out, actually. So I just think that we can maybe glean some interesting stuff out of this thing. Let's see what everybody is so fucking mad about.
Good morning. Thank you for the party's patience. Court is now in session. Calling case number 251403576, State of Utah versus Tyler James Robinson. Counsel, please enter your appearances.
Chad Ringender, Ryan McBride, Lauren Hunt, David Sturgill, Chris Ballard. For the state, County Attorney Jeff Gray, also present.
Good morning.
Good morning, Your Honor. Kathy Nestor, Richard Novak, Michael Bird, and Stacey Bird. This are here from Mr. Robinson.
Oh, and I just want to say, I know a bunch of shit's been going on in the Turtle Boy stuff as well. And, some discovery issues have been starting to get resolved. We're starting to see what Judge Gilday looks, like how he acts and how he behaves. And buckle up, y'all. That judge is not prepared for the level of celebrity that he's achieving right now. And it's not even that much. He's not ready for it. Judges are not ready for that. burden of being famous. They suck at it because they think it's so funny and cute and cool that they're famous. Like they actually think it's like a joke. So just be prepared for Judge Gilday to act like a fucking moron, because he's going to. That's going to happen. Judges are really good at being stupid when fame is on the line. Let's see. Here we go. We've got Aaron Troyer says, relevant to nothing. I have membership to only 3 YouTubers. 9 months here, baby. You, Bronca, and Joe getting news and life perspectives from 3 lawyers. Super healthy. And one of them is so good at being a lawyer, they had to stop him from being one. That's me. Chris Bookhammer, member for 10 months, is finally a respectable member length non-micropene. Finally, you're joining us in the double-digit club, and we are proud of you. We are very proud of you. Welcome to it. Okay, back to this.
Good morning.
Oh, echo.
Good morning, Mr. Robinson. And for the record, the court also recognizes the presence of
I forgot about the
Cook.
echo. I'll fix it.
Sorry. Good morning, Ms. Kirk. All right. As you've probably come to expect, I do need to read the following as it relates to today's preliminary hearing. The court is mindful of the safety and well-being of all parties, counsel, witnesses, court staff, and members of the public who may be present. The court is also mindful of its duty to protect and uphold the constitutional rights of both Mr. Robinson and Ms. Kirk. To serve those important interests, the court reminds all persons who will be in attendance that portable electronic devices will not be permitted in the courtroom or on the 4th floor.
And
this prohibition does not apply to legal counsel and support staff for the defense or the state or the media in this manner, or the equipment permitted under any electronic controlling electronic media coverage order, and includes the counsel for victim representative Ms. Kirk. I do ask the parties, the attorneys, if you will join me in turning off your ringer to ensure that we do not have any interruptions.
Okay,
I am turning off my
Grandpa.
ringer, and I invite you to do the same. Every person who is in attendance today and every day will be afforded the dignity and respect.
Mr. Mike over on Locals said, Justin from Phoenix Ammunition was on with Viva today. Yes, Justin is an ammo manufacturer, so keep that in mind. Ian Carroll got his info from Valhalla and reiterated incorrectly. What Valhalla? Not like Valhalla, right? Like a different Valhalla. What Valhalla who? And reiterated incorrectly. As far as Justin's opinion, others disagree with, because Remington's Core-Lock technology is the best-selling hunting ammo for close to 75 years. Modern Core-Lock has a 95% weight retention, meaning it doesn't frag. It's Justin's competition, so he says Remington Core-Lock is cheap and frags. There you go. So take everything with a grain of salt. Look, I'm going to word this way. At some point, you have to consider that there's a group of people who have been lying to you specifically about a bunch of stuff, stating they know it for sure. And we found out over the past couple days that they were wrong on all of it. And those people have been lying to you the whole time. And they're the ones saying different things now than what's happening allegedly in court. You have to ask, why did they lie to you for a year? And are they likely to suddenly stop lying to you after a year of doing it? Make up your own mind. Like, I'm not here to tell you who to listen to. I think just about everybody's a fucking idiot. Let's see. Jordan Patterson, 8 months of membership, says, sup, Fig? Hey, what's up, man? Nice to see you. Nice to see you. Thermasius has become a member. Welcome back, man. Nice to see you on here. Did I miss that? There. Go away. All right. Okay, back to this.
Due to them, and pursuant to the standing decorum order by the court, all spectators shall be quiet, civil, and orderly. Spectators shall not engage in any distracting, disruptive, provocative, disrespectful, uncivil, or threatening behavior of any.
Who is Valhalla VFT? Not like Valhalla awaits, not like our friend Valhalla, right? Like this is someone else. Jordan Patterson says, just kidding, love you. Hey, wait, I love you too. Why? What? which has happened, which I feel like I've been violated. Alaskan TDW. I am working on it. I'm sorry.
Kind. Spectators shall not make any audible comments of any kind, shall not shake or nod their heads, shall not otherwise make any gestures during the hearing. Spectators shall not wear or display pins, buttons, signs, clothing, or photographs expressing support for or against any person related to this case or the status of this case as a capital offense. All right. As we begin this morning, I wish to I've taken a lot of time to think about the comments made by the party.
Oh, Valhalla VFT used to be a Green Beret. Oh, that was the one Ian Carroll was like, listen to a Green Beret tell you. Guys, okay. Phoenix Ammunition, he's an ammo manufacturer. He's probably an expert in ammunition and how it works. But you don't have to listen to him. I don't give a shit. But when someone's like, listen to this Green Beret tell you about how ammunition works. Those guys aren't necessarily using the same rounds that you're buying at the local Bass Pro Shop necessarily. The types of rounds that they use as Green Berets are, they're not having to buy these. Those are supplied by the U.S. government. And, they have various specifications that they want them to live up to. I would assume. I don't think the government goes out and just willy-nilly buys some rounds. They're like, oh, these are good for what we want. No, they have, they have some idea of what rounds they want. That doesn't mean a Green Beret knows anything about the fucking manufacture or performance of a particular round. They might coincidentally know about different rounds. They may have some experience with things like how bullets perform in certain tests, like how effective they are at different ranges, how accurate they are over distance, things like that. Sure. Great. You know what they don't do? Yeah, I don't know if you guys know this, but a Green Beret doesn't go up to a target that they just put a round center mass in from 250 yards. They don't go up and analyze whether or not that bullet fragmented with inside the body and left little lead traces anywhere. They don't do that. They don't go perform field autopsies on hijabis running around. That's not a thing that happens. So when it's like, this Green Beret, blah, blah, blah. Yeah, you're much more likely to get better information out of a hunter, someone who butchers the meat that they kill. Only based Dolph Lundgren style Green Berets are butchering the meat that they kill. Most of them, just kind of leave it in the street for the local authority or governmental body to police later. Don't give false credibility to random authority just because someone says something. A Green Beret knowing about ammo would be because that Green Beret studied ammo specifically. Green Berets don't sit around manufacturing ammunition. Not really useful for them to do that. They have someone else do that. They go and shoot the ammunition into bad people. Delta Force! Winston Smith says you should see Kurt's take on these hearings. He knows nothing about trial practice or evidence, doesn't understand foundation, kept saying it was boring, which trials are. Yes. The only thing more boring than trials is Kurt's trial coverage. That's the only.
You mean judges like the bitch in my case don't know what the business when the cameras are on?
That's right. They don't know what the business. No idea.
Yesterday, and there were additional briefings and a motion filed last night, and the court took the necessary time to readdress it and look at it and be prepared for this morning's proceedings. While I recognize especially how precious our time is, I also recognize that I need to be prepared for everything that's before me, and I took the time this morning to review what was filed since we adjourned yesterday until we came back on record. One of the motions filed last night was filed by Ms. Erica Kirk's attorney. And
Mr. Mike has sent me an article on the Remington core-locked rifle ammunition. I will give it a peek. I just wanted to let you know, like, I do see it there.
I wish to address that. And I realize that the parties may not have had a chance for defense or prosecution had a chance to respond to that. And before I address that, I wish to turn the time to you if you need the benefit of the record as it relates to what was filed by the attorney for victim representative Erica Kirk to the state.
Good morning, Your Honor. Christopher Ballard on behalf of the state. We have reviewed that filing, and we believe that it fully accords with our position in our filing this morning that publishing exhibits to the courtroom is entirely...
What was this guy's name? Sorry.
Christopher Ballard on behalf of the state. We have reviewed that filing, and we believe that it fully accords with our position in our filing this morning that publishing exhibits to the courtroom is entirely appropriate and indeed honors the victim representative's right to be present at this hearing.
Thank you, Mr. Ballard. To defense, Mr. Novak.
Thank you, Your Honor. I read the pleading. I believe that every order that this court has made to date complies with and respects the victim's rights under the Utah Constitution. I think that the rulings that the court has made the last few days do so. And I don't believe that the issues that are presently before the court
9 years
going forward with the hearing with respect to exhibits in what I'll just call the 16 series interfere with any of the enumerated rights set forth in the Utah Constitution concerning the rights of a victim representative in any criminal proceeding. So that's our position. And I want to also be very mindful of timing issues because we spent a lot of time arguing without the court having the benefit of briefing yesterday.
Don't talk about shrimping.
But we have witnesses we have to get to, including a defense witness who is not available after tonight. So I could, of course, as Your Honor knows, say much more, but the court has all the briefing, and I think we should move forward.
Thank you.
Oh, that guy's got a space laser on speed dial. Okay, one thing that we should put out there, I don't know if I ever adequately prepped this out for people. This is a probable cause hearing. This is not a trial. And so typically speaking, I mean, I know that the defense is going to bring someone. He just said we have a defense witness who's only here for today. That's all we got. The defense having any witness present at the probable cause hearing is strange. Unless, like, how do I explain this? Everything in a probable cause hearing gets the deferential towards the state. Everything is deferential towards them. And all the state has to do is show that they've got probable cause that a crime was committed by this person. So they filed the charges. That's all they have to show. That's it. That's not much at all. They have this in spades. There's almost no reason for the defense to present anything because in a conflict of fact between a defense witness and the state's witness will win at this stage. That's not weird. That's not bad. That's nothing other than the probable cause standard. Do the facts as presented most favorable to the state show a higher likelihood than not that the defendant committed the crime he is accused of committing. That's probable cause. Again, all factual matters resolved for the purpose of determining probable cause in favor of the state. So if there are two conflicting times, the state says it was 3 o'clock. The defense says it was 3:15. It's 3 o'clock. It may have been 3:15, but for the purposes of this hearing, it's going to be fucking 3 o'clock. You can only bring in, or the only reason as a defense to bring in any witness is to completely annihilate a factual matter from the state, which is really hard to do. I don't know if you guys know this, but court is literally he said, she said. It's very childish. And so when you have that he said, she said, and the court says what he said matters and what she said doesn't for the purposes of this hearing, there's almost no point in saying what she said, because what he said is the only thing the court cares about. So you have to completely annihilate a fact. You have to show it to be impossible or otherwise completely inadmissible, and notoriously so. There can't be a fight over it because you lose. That's the way that probable cause is set up. This is not trial. At trial, they will get to challenge all of this stuff in different ways. This probable cause hearing, that's all they have to do. And people, again, if you think they have not got probable cause on this case, you are wrong. They have it. They have it easily.
And as it relates to transparency and
that looked
publication,
like Ben
does the
Stein.
news media wish to be heard on this issue?
Only briefly, Your Honor. I've also reviewed the submission from yesterday. The court has always set this three-step process, and I think taking each of those stages, admissibility, publication to the courtroom, and coverage by the in-court cameras are three separate inquiries. Of course, the media will be the party who stands here at this lectern and says, we believe we should see as much as possible, maximalist in that way, while recognizing the importance of protecting all the rights, including fair trial rights. But the idea of publishing something, of keeping something off of the cameras at the rear of the courtroom, but publishing it to those who are present here also is a meaningful step towards transparency. And to the extent that the court is not comfortable with placing something on the video feed, the media does believe that allowing the media representatives who are here and the members of the public who are here to view that, even if those watching on a live stream cannot, is a meaningful victory for transparency, and we of course support that.
Thank you. All right.
Your Honor, the state would like to be heard on the briefing briefly.
For
The briefing that was submitted last night.
all right, so I want to address the motion filed by the attorney for the victim representative, and then we'll transition to that. I'm just trying to do it incrementally so we can get it all addressed. So in regards to that, and I appreciate the position of the parties, it is important for me to hear.
Aaron Troyer says, I love you, but my brain can't listen on any speed greater than normal. I've tried many times. See you on the flip side. I'll tune into the next show. Yeah, sorry. I know it's not. I don't like these glasses at all. I know it's not for everyone. I know it's not for everybody, but otherwise it's watching 6 hours of this, and a lot of people have already done it. So I just don't I don't know that we need to do that. I don't even know if we're going to watch the whole thing. What I want to do is start getting into this evidence that starts coming in throughout the day, because this is, based on the reports I've seen on Twitter, this is pretty damning. Aaron Troyer also gifted a membership. What a sweetie. Thank you, Aaron. We'll see you next time. And thanks for being here.
Hear all sides. Article 1, Section 28 of the Utah Constitution recognizes important rights afforded to victims and victims' representatives, including the right to be treated with fairness, respect, and dignity, and the right to be present and heard at critical stages of the proceedings. The court acknowledges the concerns raised in the motion regarding transparency and the ability to meaningfully observe the evidence presented during this hearing. At the same time, the court has an independent obligation to manage these proceedings in a manner that safeguards the rights of all parties. That includes honoring the rights of victims and victims.
Okay, we're gonna do this real quick. Plasma B over on Rumble, although I'm not able to pull it up for whatever reason, says autopsy pictures is all the defense needs to get a dismissal. They aren't. If autopsy pictures would get the defense a dismissal, they would have already presented autopsy pictures and gotten the dismissal. That's not how that goes. So I just want to point that out to you, that the defense has had the opportunity to present said evidence and obtain said dismissal, and for whatever reason, they decided not to do that. This is something that you need to get used to. If you are on the side, it's not the side of like Candace Owens. I don't know whose side these people are on. I don't mean it that way, but if you are following and absorbing and believing the stuff that's being relayed by Candace Owens and Ian Carroll and people of that ilk, get used to the fact that you have been told a bunch of things that will show that Tyler Robinson's not guilty, and the defense is not going to do it. Like, they're not going to. Now, if the defense presents autopsy photos of Charlie Kirk, which they might, I mean, the prosecution is probably going to present those pictures if they exist. But if they don't, and the defense does, don't expect a dismissal, because we're at trial. There isn't a dismissal. Once we get past probable cause, I should say. Once they get past this probable cause hearing, this is where dispositive motions happen. There isn't a dismissal at that point. There's trial. Get very used to this thing where someone says, oh, if they just present this, they'll just win, because they're either not going to present it or they're going to present it and then court will just move on and they won't win. That's something you need to get.
Representatives while preserving the defendant's constitutional rights, including the right to a fair and impartial process. The court has considered the request that exhibits be displayed in real.
Shelley C., member for 26 months, has pulled for 5th District Court jury pool in October. Ugh. That sucks.
Time to the courtroom. After careful consideration, the court determines that not all exhibits will be visually displayed to the gallery, and notes that it will use a tiered method as described. First, whether it will be admitted to the court for consideration as it relates to probable cause. Second, whether it will be displayed.
Plasma B. If you want to create the world in which everything is not falsifiable and therefore is not assailable, okay. Well, the autopsy photos would prove a rifle didn't kill him, which is why we won't see them. We'll never see those. Well, why? Why wouldn't the defense present the autopsy photos? Why wouldn't they do that? A series of bats, member for 6 months, says need a short sleep shaming. Insomnia and narcolepsy like you. You need a sleep shaming? Why? Because you're sitting here awake? Some kind of loser wanting to be conscious during the day? Have you even heard of box breathing, you little bitch? Have you even heard of it? Have you sat down, sucked in air, held it in, breathed it out, and fallen asleep like a man? No, you haven't, have you? You just sit around whining about how I can't sleep. It's not right. Shut up. No one wants to hear it. They want you to shut your goddamn mouth, close your eyes, and go to bed. Sledge Entertainment. Nick, I'm late. You're gay. Rip Charlie, he was one of a kind. Hope you're doing good, and shout out to the micropeens. I am. I'm doing well, actually, and I'm doing good because I just shamed someone who deserved it.
Only to the gallery, and third, if it will be published through the camera to the public at large.
I like this one.
This ruling is not intended to diminish the significance of the victim's representative rights or concerns. Rather, it reflects the court's responsibility to regulate the presentation of evidence in a manner consistent with the integrity of the proceedings and the fair trial rights implicated in this manner. The manner in which evidence is displayed remains in the court's discretion. That discretion must be exercised in a manner that is appropriate and appropriately balances Mr. Robinson's constitutional rights, Ms. Kirk's rights as a victim representative, and the court's obligation to conduct the proceedings that are fair, orderly, and appropriately transparent. Transparency is an important principle, but it must be maintained in a manner consistent with the constitutional rights and protections afforded to all parties. The court does not make a blanket ruling as it relates to any exhibit, and as previously stated, each exhibit will be afforded its own due in weighing whether it shall be published to the courtroom or beyond or not. And that concludes the court's ruling on that motion. All right, counsel, the last matter, as it relates to the briefing, I'll hear that, and there is a slight edit to, and I'm not sure when the state wishes to publish State's Exhibit 16. So turning to the state, do you wish to be heard about the motions filed last night prior to the publication of Exhibit 16? Again, it's your choice on how you move forward. I just want to see which order you want to go.
We do want to be heard on the briefing from last night, and specifically about Exhibit 16. I'm understanding.
Why do you think I would run from a goose? Would you, if you're getting chased by a goose, are you not fist fighting a goose? Yeah, you can't lose that fight, right? Like if you do, you can't show your face ever again. But I am not running from a fucking goose. Hey, what's up, AJ? I saw you. I saw you there. Where'd you go? There you are. Hey, what's up? That's not you. There's AJ. How you doing, AJ?
Your Honor has an additional edit to that. Is that
I
correct?
do. There might be value in hearing that, so that may or may not change your positions. So let me just put that on the record, and then I'll hear from you. I just want to make sure you're able to
I'm gonna
be
rip
afforded
the eggs
everything.
out of that motherfucker.
So as it relates to the edits, last night, I believe it was between 6 minutes and 57 seconds and 20 minutes and 29 seconds, which is not to be played, and then 32 minutes and 55 seconds to 35 minutes and 47 seconds, which is not to be played. And I believe that what I received reflects that. And is that the understanding of the parties?
Yes.
All right. The state has said yes to the defense. I'm not saying if you agree with it. I'm just saying, does it reflect the timestamps? Absolutely.
Tell me about dry eyes, Mr. Stein.
Go ahead, Judge. I think, Your Honor. And then let's just see what the court is referring to.
Well, I'm asking, did you receive a copy of the edited video?
Okay, so I'll answer that question directly. The state sent us a copy of the edited video. The redactions of the audio were exactly as the court ordered, but we noticed that the video, which followed, ended up being inconsistent with the redactions of the audio. So I brought that to the state's attention last night. I believe that they ultimately forwarded to the court what I'll call version 2 of the redactions, which redacts the video that would have made the audio redactions sort of superfluous or ineffective. So that's sort of where we are. But we may be not communicating with each other about the same issue. I'm not sure.
Well, okay, I just want to make sure that in regards to what was to be cut out comports with those timestamps I just gave.
It does. Plus, the parties believe that additional video needed to be cut out to match the court's intentions with respect to the audio.
Right, and this is what I'm going to next. Mr. Ballard.
Yes, Your Honor. I think we're on the same page. We did, in conjunction with discussions with the defense, first of all, we prepared the redacted video as Your Honor ordered. Then after discussing with the defense, we prepared a second version that still maintained the audio redactions as the court ordered, but we took out the video portions that the defense brought to our attention.
All right, and I didn't see that, but here in this...
Do you guys do this? Do you guys take like a brick of cream cheese and then pour salsa all over it and then just eat it with chips? Like, do you... That's delicious. If you have not done it, I strongly recommend it.
This is the court's own independent finding after spending significant time last night reviewing it. So I'm requesting a video-only redaction between 20 minutes and 29 seconds and 25 minutes and 23 seconds. And so what I looked at was what was on screen. So any video showing anything other than Mr. McBride and Lance Twiggs was to be redacted, with the exception of the screenshots of the images pulled from the surveillance video and the FBI bulletin, which I believe was also briefly displayed.
Peachy, you know the answer to this. I'm on a plane with cocaine.
I think we're all on the same page.
Yes, I'm
based on what the court just said.
up again.
Your Honor, I think we have just a 1 second difference. Our timestamp is 2522 of the additional edited version, but I think it still omits the video portion that we're discussing.
All right, well, it's a good day when we are literally on the same page. I'm glad that within 1 second we are all in agreement.
Oh, we might have to take a brief pause. Let me. Oh, whoa. Hold on, I think this is it. Okay. Here we go.
Out. If she's a grown adult woman who doesn't know that thunder comes from lightning.
And then my husband was like, you know that it can't thunder without lightning, right? That thunder is the sound of lightning. My mind was completely blown. I promise you, in my 35 years of living, I had never heard that.
If she...
No! That's... What did she think it was? Do you think it was just a fucking coincidence? Like, oh man, every time the sky lights up, it goes, whoa. Ah! This is the person that everybody believes. I promise you, in my 35 years, I never knew that until my husband told me that I was fucking dumb. Can you imagine being her husband and having to explain, like, there has to be lightning for thunder, right? Like, that has to happen. Like, right? You do know that, right? Can you imagine? You may be the gentlest soul on the planet, and right then you're like, domestic abuse is a good fucking idea right now. Like, I cannot believe I'm explaining this right now.
doesn't know what temperature ice melts at. And if she can't pronounce any word over 2 syllables...
Hyperbolic, the architecture. An anecdote, grandois, they are more satiating. The burrow of alcohol and tobacco. Retired green beret, raspberry beret. There is something so reminiscent.
Then she's...
She's so dumb. Raspberry beret. Raspberry beret. I can't take it. Oh my God. Miss Peachy says, hey chat, remember there are super tips and super chats. Getting Israel vibes tonight with the lack of tips. Oh my gosh, just a tip. Also, I might have said the same thing about Thunder and Lightning. At least I can blame years of drug use. I can't imagine not knowing that. I can't even go, like, I can't go back to my youth and go, when did I discover that? Because it has always been. It is known. It is known. Eclectic Deb. I really appreciate the way that you described the loss of Charlie and that he carried the thoughts and visions of millions and that was snuffed out and then mocked. A significant loss for this country. I may make a lot of jokes and stuff, but the Charlie Kirk shooting really did. It really kicked my ass in a way that I wasn't expecting because I'm a cold, heartless monster. But yeah, you got 20. This video is 1 minute long and has more comedy in it than...
She's not a brilliant, brave, truth-telling homicide detective just asking questions. She's an illiterate, elbow-licking moron who needs Velcro shoes because laces are far too difficult.
Like I just said, had a vivid dream this weekend, and Charlie came to me and he told me that he was betrayed.
And so is anyone taking her seriously.
That's... That's real? Like, that's what it is? Oh my God. That's the fucking best. Uh-oh.
I abused my goose and went to sleep early in hopes you were gonna stream. Can't wait for micropene brisket bullshit.
Why are you ignoring evidence that doesn't exist? John's dead.
John's dead. John is dead.
agreement about this. So that the court, and it sounds like you're one step ahead of the court. I was going to say that if you had it, you simply turn off the monitor for that section. But if you've already made that change, then all the better. There are 2 additional changes as well. And this is very short, and so I'll leave it to the state. If you wish to just in real time pause and fast forward, or wish to redact it, I'll leave it to you. So the additional requested audio and visual redaction, so this is not to be played whatsoever, is 27 minutes, 18 seconds to 27.
Megyn Kelly's been kind of like running screen for Candace, right? Like, is that what I heard? I think that's what I heard. I may be wrong on that, but that's what I remember hearing.
Minutes and 25 seconds. And the second is 28 minutes and 11 seconds to 28 minutes and 18 seconds.
Your Honor, just to make sure that we've got that correct, the additional redactions would be 27 minutes and 18 seconds to 27 minutes and 25 seconds.
Correct for the first one.
And then 28 minutes and 11 seconds to 28 minutes and 18 seconds?
Yes.
And Your Honor, while we're talking about additional redactions, let me approach.
If I was a judge and they said, let me approach, I'd be like, no.
When Your Honor made his ruling yesterday afternoon, it wasn't entirely clear the basis for these redactions that the court proposed.
Wait. Megyn isn't on the Candace wagon, but she just doesn't think this was necessary, thinks the judge is being weak. What do you mean she doesn't think this is necessary? The probable cause hearing? The defense challenges probable cause. The defense does this. Like, she knows that, right? Like, the court doesn't just like go, you know what? We're just gonna do this probable cause hearing out of nowhere. The court doesn't do, like, you challenge the probable cause or you accept probable cause. That's what happens. Is Megyn Kelly a lawyer? Really?
The state's understanding was that those additional redactions were based on the potential that the video 1102 would be showing duplicative evidence and would be displaying evidence that would be duplicative of future exhibits, and then also potentially a concern about admissions by the defendant.
You're from Hamlet.
Portions that the court has ordered to be redacted do not have any of those concerns as far as the state's view of that evidence, and I'd like to be able to point the court to those. We've got 2 brief portions that we believe don't implicate those concerns and should not be redacted. Right. Does Your Honor have the transcript in front of you? Okay.
Man, I want those chips and that fucking salsa and cream cheese. I wonder if I can...
First of all, at the very, very bottom of page 10, beginning with the words, was he? And then over to page 11, down to timestamp 1646. That portion is not cumulative of additional exhibits, and it contains nothing that could be classified as an admission by the defendant. That's the first portion.
So going back to page 10, I don't see was he at the bottom. Where are you? How many lines from the bottom up are you referring to? You may. Oh, I see. Right here. Okay, now I see what you're saying. I missed that. I was looking at the beginning of the line, but I see your point. Okay. So from was he on page 10 until
16, the timestamp 1646 on page 11.
Okay.
That's the first portion. And then the second portion that we would ask not to be redacted is a small portion of page 19. And it begins...
hopefully that balances out the volume a little bit.
It would be the 5th paragraph down, Mr. McBride stating, okay. And then ending at timestamp 3340. Again, that's not cumulative of any anticipated exhibit, and nor does it refer to any admission by the defendant.
Thank you. Yes, you may.
Well, I might have to run upstairs and grab some, grab that chips and salsa.
With respect to the first of the 2 portions that Mr. Ballard referenced, I want to be totally transparent with the court, of course, that was not a section that we asked the government to agree to redact. That is a section that the court independently determined was appropriate for redaction under the various principles that the court has enunciated. So I just want to be transparent about that.
Thank you.
The second portion that Mr. Ballard addressed, which is on page 19, we did suggest, and it is in our highlighted, redacted transcript, and the court agreed with us, this is not relevant.
I have like a...
This is not admissible under 403. I don't understand how this questioning by Mr. McBride and the answers to these questions by Mr. Twiggs, and now I'm going to quote the Utah Rule of Evidence, has any tendency and reason to make a fact of consequence more or less true. That's the relevance question. So I understand that the court has said, I can make determinations of which portions of this transcript to rely upon, but from my perspective, what the state is asking the court to do is to broadcast a portion of the transcript, which we are saying is not relevant, and to the extent it has any relevance, is significantly outweighed by undue prejudice.
All right.
I am not Mr. Twiggs' representative, but I think as a witness who has counsel, there might be something that Mr. Twiggs' counsel would want to say about this as well. I don't know what it would be, but my firmly held belief is it would be consistent with what I'm saying, which is that it is neither relevant nor probative of anything
I wasn't penis
of significance,
gouging. My mouth
especially
isn't
compared
bruised.
to the undue prejudice. Thank you, Your Honor.
Thank you, Mr. Novak. Mr. Ballard.
Okay, so that's him trying to get the interview or the I guess the Tyler Robinson's roommate, right? Like the questioning of the roommate. So I don't see how that's relevant. I do.
Thank you, Your Honors. Mr. Novak recognized Mr. Twiggs was represented during the statement. His counsel knew that this was being prepared to be produced in court, and his counsel made no objections to this part of the interview. And this is critically relevant. It provides important foundational information about Mr. Twiggs and identifying information about him, and then also it's very relevant to the enhancement that we have charged.
All right.
I'm the least scary villain of all time.
Anything further before the court rules on
Twiggs.
these two requests? All right. In reviewing the first section, again, citing to page 10, and I know it's to anyone listening, this may not make sense when I'm saying page 10, but it's roughly just a few seconds after 1539 on the video, starting with was he, and ending at 1646, with the last word asking. After hearing and considering what has been argued, the court agrees that this, in applying a balancing test and as it relates to transparency, to ensure the court is taking a very narrow approach in what is or is not published to the public, that this is permissible. It doesn't run afoul of the issues that the court addressed previously, that the court is trying to avoid by publishing portions. And in addition to that, independently of the court's decision-making, it appears that parties also agree as it relates to the first requested edit to unredact or to allow in. So I am ruling that that may be played and published through all mediums in the courtroom and via video. Turning to the second section, this is page 19. It is roughly right after 3327, going to just before 3340.
Sorry, Your Honor, just to clarify, what we asked was just before 3307.
3307?
Correct. Yeah. Yes. Right after 3255, where Mr. McBride states, "Okay."
This is a good quick jumping off point for this. Twiggs lies in his interview with him and Tyler, or lies in his interview. He and Tyler went to the No Kings on June 14th in St. George. Okay. At probable cause hearing, that doesn't fucking matter. Completely useless. Does not help the court to know that he lied there. It's not even worth really attacking. At trial, that becomes a credibility issue. You want to bring up that lie and inconsistency at trial. That is way more important there than here. And that's one of the things, again, that people keep missing about what a probable cause hearing means, what it's for, what its purpose is, and how they function. CL Love, 1977, member for 14 months, says, my turn, heart when I get to wave my generous member. It is voluminous. It is large and long. Thank you for having it and sharing it. Bob Tube says, congrats on 12,000 pages. Thank you very much. I am proud to have completely taken over that stupid website and creating an entire class of people that are all simultaneously obsessed, lonely, and horrible at the same time. I found them all and I put them in one place. I have like a retard rake. I just went through the yard, scooping them up and dumping them into kiwi farms. It's fantastic.
I see. Thank you. Let me just take a quick second to review this. In relation to that request from right after 3255, starting with OK, is that the spot you're talking about, Mr. Ballard?
Yes, Your Honor.
All right. And specifically to 3327, the court stands by its original ruling. That is not, there are several reasons why the court, the court's ruling isn't whether it's relevant or not. It's whether it should be published or not. And again, as previously stated, the entirety of Exhibit 16, the court is receiving without any redactions or edits. The court is considering it as it weighs probable cause. However, for publication, the court finds that the requested section from roughly after 3255, starting with OK, ending at 3327 is, the court finds that there are interests served by not publishing this to the courtroom or to be broadcast. I note and I recognize Mr. Novak's statement as it relates to what Mr. Twiggs' counsel may or may not assert, but the court finds independently that this this portion shall not be transmitted into the courtroom because of certain statements made in there that do not serve the interests of justice for publication. However, the court finds from 3327, starting at OK, until just before 3340, I'm sorry, up to 3340, may be published. Did that notation make sense?
Yeah,
to the state, Your Honor.
All right, to defense.
Understood.
And so this is
Tell
the
him
appropriate
I might in a
balancing
second, but my son was just
of being
texting me,
transparent
so
while at the
he's
same
away.
time maintaining
I'm
the
like,
constitutional rights,
are you, like,
or balancing the
up out of
constitutional
bed?
rights of all parties and what is appropriate for publication. And this may be published not only to the gallery, but to the media as well, that goes beyond the gallery itself.
Kiki, I think you just
All right.
underestimate just
Anything
how
further on State's
interesting
Exhibit
I
16?
am.
Not from the state, Your Honor. Thank you.
Did you know that I sometimes like go to the
I know
bathroom?
defense
and
is
stuff?
nodding their head as well and
That's a page.
not indicating any more is needed to be discussed at this point. All right, I think we've put State's Exhibit 16, we've addressed it. Turning to the state.
Thank you, Your Honor. We would just like to briefly emphasize a few points in the briefing that we filed early this morning. Last night, the defense raised the issue of publishing admissions by the defendant or confessions. They cited to one sentence from the United States Supreme Court opinion in Estes versus Texas that relies on the Rideau versus Louisiana case. And that one sentence in Estes.
It's not redo, it's Rideau versus Louisiana. It's like the French spelling. Speaking of the French spelling, Cool Frog has rated this stream over on Rumble. Welcome to Cool Frog and all of his viewers who are now mine. You've been stolen.
Estes has no precedential value on the issue that's before the court today. Estes cited to the dissenting opinion in Rideau, which is very curious because that dissenting opinion, Rideau was a change of venue case. And what the dissenting opinion held is that the court properly refused to change venue in that case, even though the defendant's confession had been televised multiple times. So it's puzzling that that's what the Estes court would rely on as supposedly constructing some kind of rule about publishing a defendant's admissions. In addition to that, Estes has no analysis of that point from Rideau. Again, it's just one sentence. And Estes itself was a case about televising a trial. It wasn't about pretrial publicity of a defendant's admission or confession. And
Third Railify has rated this stream. Hey, man, wasn't it your birthday the other day? I think I heard it was your birthday. Happy birthday, if that's true. Thank you for rating. Welcome. Welcome to all of your beautiful viewers. And I think I went on the Third Railify show before, I think, right? And we had a good little chat or whatever.
In the brief, subsequently, the Supreme Court has limited, although it hasn't expressly overruled Estes, it's limited that case to its very narrow facts. So it's
I do apologize. I was invited onto your birthday stream, and I really did want to pop in there, but I had just I think I just passed out asleep. I've been having some really long days that have been a little bit stressful. So I apologize for not making it over there, but happy birthday and welcome here.
Difficult to see what precedential value that one sentence from Rideau could have on this issue before the court. Even if it could have some applicability here, the circumstances in Rideau are starkly different from the circumstances here, the types of statements from defendant that we're talking about. In Rideau, what the police did was orchestrated a recording of an uncounseled, unmirandized police interrogation. The police recorded that interrogation. It was leading questions. They recorded the defendant answering those leading questions. And then it was the police that immediately released that recording to the press, who then publicized and televised that. The defendant confessing to police, answering the police's questions. That's not the types of statements that we're dealing with in this case. What we're dealing with are statements that defendant voluntarily made to close friends and associates of him and his roommate.
Okay, so just to clear that up in case anybody else got kind of lost for a second, because I I zoned out and zoned back in. It sounded like he was saying that someone made statements after being Mirandized and they were leading questions, et cetera, et cetera. That was a different case. That was the Rideau case that he's talking about. And he's saying it's way different than what we have here, which are statements to friends and family and admissions in that case, and not basically horse-led confessions to law enforcement post Miranda. They're very different. That's what he's pointing out here. Like this case is not really a good case for the present case against Tyler Robinson.
Sorry, just one other point about Rideau and that dissenting opinion. It's interesting that in that dissenting opinion, that judge that the court relied on in Estes continued on in his opinion and said it's an impossible standard to require that a trial court be a laboratory that's completely sterilized and free from any external factors. So again, it's hard to see how Rideau has any precedential value.
Holy shit. Who is smart? Me. Remember what I was saying about the undue external influence. A big part of that is it has to be undue influence. Like he said, a courtroom cannot be a sterilized place that has no influence at all. Influence exists. What is this hair? Influence exists the moment something happens that you observe. You're influenced in some way by that thing. Now, it may not be relevant to the court case, but if anything happens related to that court case, you're going to have some influence. But it's not undue influence at that point, and it's not insurmountable. Remember, these judges can fix any mistake just about with what's called a curative instruction. I'm being cheeky on this because we all know that's bullshit, but they believe it. They believe they can fix almost anything with a curative instruction. Ignore that line. You didn't hear that line. We're going to strike that from the record, and you are not to use that in your deliberations about whether or not this person is guilty or innocent. Well, what's the first thing that person's going to think of? Oh, hey, tell me not to think about this. I wonder why. If you can cure any sort of defect with a curative instruction like that, you don't have a taint that, like, tainting a jury pool is near fucking impossible.
And Even if it did, the circumstances are completely different than the
What's up, Nana
from the
Bear?
types of statements
How are you
that we're dealing
doing?
with here. The state has also cited to several other courts that have easily distinguished Rideau and have made it clear that there is no blanket ban on publishing, especially just in court, a defendant's voluntary admissions. I think the most interesting case is the Sixth Circuit case, because there it dealt with essentially the issue that we're dealing with here, which is publication of a defendant's statements during a preliminary hearing. And that case is especially important, the DeLeslie case, because there that confession was ultimately held to be inadmissible. So an inadmissible confession was played to the public and interested media members so that in a way that it had, as if it had been played in a preliminary hearing. And even though that confession was subsequently publicized and ultimately held to be inadmissible at trial, the court did not hold that that was a violation of the defendant's fundamental rights there, that the court could deal with that through voir dire. It was not inherently prejudicial. And then the state has also cited to the Ohio case of Mamon, and then also the Alabama case, Burgess versus State, where those courts reached essentially the same holdings, easily distinguishing the Rideau sentence from Estes and making it clear that there's no blanket ban on publishing a defendant's admissions, and also that Rideau is easily distinguishable. And because the court can deal with those pretrial publicity issues in the way that we've discussed several times already through the tools that the court has available in selecting the jury. I think it's also important to point out that transparency is critical in this case. This court's noted repeatedly the extensive media coverage. That's why we're having to take this additional time in these hearings to be able to discuss these issues. And transparency is critical to the state's right and the people's right to a fair trial, where there's a vacuum in the evidence that just fuels speculation. And then finally, as has already been argued, it's critical to the victim's right to be able to attend the hearing. That's a hollow promise if the victim representative is only able to be here physically, but then is shielded from some of the evidence. Does the court have any questions?
No, not
Thank you.
at this time. Mr. Novak.
Thank you, Your Honor. The parallel between Mr. Robinson's case and the Rideau case is this. Mr. Rideau's confession was televised by an act of the state. It wasn't a confession broadcast through a courtroom. It was a confession made to law enforcement and then broadcast by action of the state. And that's what gives rise to the constitutional problem, which is its state action, which violated Mr. Rideau's right to a fair trial. This court has granted the media's request to electronically publish this entire proceeding.
Yeah, who cares?
That state action. And the state has supported the media's request over Mr. Robinson's objection. So that is also state action. So that's the parallel. If there were no cameras in this courtroom, we would not have a problem. And in fact, Ms. Kirk's attorney's briefing seeks a remedy.
Sorry. One thing I left out earlier is there is, when I said that there is no right to a private trial, that's true. There's no right to a private trial, but there is a right of the press and the public to public access of a trial. So consequent to there not being a privacy right, there is a specific public access right, and it is a right of the press and of the public to have access to public trials. That is a right. To impede that right requires a justification. That justification being a competing right that it's butted up against, or that's it. That's it. There has to be a competing interest, and that right has to be infringing that competing interest, and it has to be in the interest of the court to honor the competing interest rather than the right of public access, which is part of the free press, which is a fundamental right in the First Amendment. I don't know if you guys know that. You probably do. You maybe learned that in school.
Which has nothing to do with the cameras in the court.
Oh, so this guy is sitting here saying, now that doesn't mean there have to be cameras in the courtroom, but once a trial is open and a proper media request has been made following the rules of the local court, it's really hard for a judge to say that, well, we're not going to have cameras in there unless the judge makes a finding, which would be reviewable then upon appeal. but it makes a finding that the presence of cameras in the courtroom, for whatever reason, is so disruptive to the court's ability to conduct a trial that they need to eliminate the cameras from the courtroom. And again, of course, if something were to happen with the cameras that would somehow, taint his ability to have an impartial jury under the Sixth Amendment, that would be a problem. But that is it's such a high bar. It is such a high bar. Oh, and one other thing I was talking about and didn't wrap up. I'm thinking about it now. I said we can't just curtail everybody's First Amendment rights, like on the altar of trying to make it easier to find a jury. But it's really important to note that the undue influence that the court is trying to avoid is generated by the court itself or the state. It's not because an influencer talked about something. Someone with a big following talks about something and it happens to be persuasive. That doesn't mean that that's a tainted jury, and that doesn't mean that that's undue influence or anything like that. It has to be an action of the court, because the court can do certain things to people who are in the courtroom, like they could hold them in contempt, etc., and that stuff. But the court isn't in control of people. The court is in control of itself. So what the court does has an effect on the defendant. And if that, or on the jury, for example, if the court does something that impacts the ability of the court to conduct itself, or of the court to provide that, impartial jury and due process rights to the defendant, if the court does that, that's a problem. If other people are talking about it, that's not a problem. And Erica Kirk gets to say whatever the fuck she wants because her husband got killed. And that's a weird thing, but she gets to say whatever she wants. She gets to say, she can walk to a press podium tomorrow and say, Tyler Robinson is an N-word that killed my Charlie. And he did it 100% sure. She can go say that. And there's nothing the court can do about that. That doesn't taint a jury pool. That's not undue influence. It's nothing like that at all. That's just someone expressing their free speech rights. And she has those rights. She gets to say them. So just so we're clear on that stuff. People seem to be confused on some of this stuff.
What Ms. Kirk's counsel seeks is the opportunity for people in the courtroom to see the evidence. So the state is going to...
Do I let my son wear all my awesome shirts, or are they too small for him? My son, I think my oldest son wears the same size shirt I do in concept, but I think he'd probably have a little bit smaller neck than I have. Oh, excuse me. But no, he could wear what I would share my clothes with the kids. They just tend to they don't wear dress shirts or anything like that. They wear like athletic clothes. I don't know why. They're not athletes. Just kidding.
And further than Ms. Kirk's counsel, the state wants to publish what it calls confessions in the same way, essentially, that the state published Mr. Rideau's confession. Now, the only other thing I want to talk about is that...
No, they don't.
Mr. Ballard's correct that the blanket rule that there is unrebuttable prejudice that's stated in Rideau. We could talk about why dissenting judges say, oh my God, the court has established a rule and I don't like it. That's what's going on there. But it was in the Skilling case, Supreme Court decision in 2010, where the court said, yes, we really are going to let judges decide whether potential juror exposure to pretrial publicity makes them unable to serve. But there is an extreme case. That's not my language. That's the Supreme Court's language in Skilling. There are extreme cases of pretrial publicity where prejudice is going to be presumed. And so that's obviously about what has to be proven in terms of the prejudice. But when it's an extreme case, what the Supreme Court is saying in Skilling is there's a presumption. And I believe that this court has already made findings over the last 9 months that this is an extreme case with respect to the quantum of pretrial publicity, the way in which it's being monitored by the public, the the speed with which these proceedings, even this week, are being dissected and broadcast through all of the technology channels that we have. So it's our view that this is the extreme case that the Supreme Court talked about in Skilling. We wouldn't have any state action giving rise to this problem if we didn't have cameras in the courtroom. And that's why we think that Exhibits 16.1, 16.2, and 16.3 need to be managed in the way we've asserted. Thank you, Your Honor.
Thank you. Mr. Ballard.
Thank you, Your Honor. Just briefly, Mr. Novak's misrepresented the state's position. We're not going beyond what the victim representative has asked for. As we made clear in our briefing this morning, that we filed this morning, we are asking that these exhibits, unredacted, be published in the courtroom. Not electronically, but they be published in the courtroom. It's not the camera in the courtroom that's the problem. The issue here is the public's right. This is a public hearing. The court's ruled that it's a public hearing. Kearns Tribune recognizes that preliminary hearings are public, and the public that is here in this courtroom should be able to see the exhibits that are admitted and that the court is going to rely on. And that is even more important to the victim representative's right to be able to be present and to observe these proceedings. Thank you.
All right, counsel.
Your Honor, if I may, I'll be brief. I want to begin by saying thank you to both the parties, to the state, to the defense, to the court. Today, the time that's being taken today and the nimbleness that's required to talk about things like a transcript in open court is a challenge.
Nimbleness.
Recognize that it presents difficulties and that it takes time. And I want to begin by thanking both the parties and the court for taking the time to do that. It's important to the public, and I appreciate the court doing that. And I know the public does as well. The only thing that I want to say with respect to this question about admissions or confessions is something that I hope will help the court. The court is looking at Rideau. It's looking at Estes. These cases from 50 or 60 years ago in a different media environment under the United States Supreme Court. I want to urge the court to do what the court has done before, and that's to look at Algier. This is a 2011 Utah Supreme Court case. It's obviously in the wake of Rideau. It's obviously in the wake of Estes. It's here in this state, unanimous Utah Supreme Court, upholding a decision made by Judge McCleave below in a case that has striking.
This guy comes in, he's like, yeah, we're talking about these 50-year-old cases. What about this one? Right here in town, recently.
Parallels to this one. In the Algier case, there was a murder trial. The court received a letter, a notarized letter from an inmate saying the defendant in this case has confessed to me. Told me that he was involved in the shooting, gave me details of it, threatened me and my family if I did that. I want the court to know that. That was provisionally sealed for many of the same reasons that the court could conceivably consider keeping some of this information from the public. The court did a two-step analysis. It began by trying to determine whether or not there was a presumptive right of access to that document. The answer is yes. There is a presumptive right of access to this proceeding as well. Like Mr. Ballard just said, because this is a preliminary hearing, there's presumptive right of access for the public. The second question was simply whether there's some kind of balancing that should be done. Notably, in paragraph 17 of that Algier case, it stressed something that we have said over and over again, which is much of the information that would be revealed through that letter had already become public at that point. And the idea of sealing a document that contained allegations or details that were already in the public sphere would only create the impression that information was being kept from the public when it was not. We stressed what we did yesterday, that as we understand it, much of the information that is now under consideration for the court is already in the public sphere. The right case to analyze this under is Algier. Algier would dictate in this case that the court recognizes a presumptive right of access to this material, and that the presumption, the balancing test that would be needed to overcome that presumption of access has not been satisfied here, particularly because so much of that information is already in the public sphere. That must be an animating factor here, and we ask the court for that reason to grant access, both publication to the courtroom and, in our view, publication on the cameras as well. But
so I think this must be the media lawyer or whatever. But he's sitting here saying that, there is as I said, there's a right of public access. It's not just it's not a suggestion. It's not a privilege. It's not, the public has the ability. The public has a right of access to what happens at this trial. They have a right to it. And that right can sometimes can run up against another interest. And in this case, the court is considering whether publishing these things into the public could cause problems. And this guy's argument is pretty simple. There's a balancing test. You have to balance, which right wins. And one of the problems with the balancing test so far is all this stuff's already in the public. So it's not going to really cause any more trouble than it, quote unquote, already has. The damage is effectively done on these things because it's already out there. So what good is this? Why are we doing this with the court's energy here? Brandon Spencer says, here's a few bucks just for that shaming. Lulled like the old days from the American hero Kyle Rittenhouse trial. 30-06 would have removed CK's head off. Continue. Thank you. I will do so.
again, do recognize that middle step is a meaningful one. And if the court were to decide that information be shared in the courtroom, but not on the general feed, we would recognize that as well as a meaningful step towards transparency in this case.
Counsel?
Good morning, Your Honor. Jeffrey Nyman on behalf of the Kirk family. And we appreciate the court is trying to balance here, but the Kirk family's waited 10 months for this hearing. And they have a right to be here, and they have a right to hear the evidence. They have a right to see and feel what's going on in this courtroom.
Yes.
Just like they want to understand, Judge, what you are viewing. They want to see the evidence. And we understand you have to balance. But at a minimum, this courtroom needs to be open for the evidence to be displayed openly in this courtroom, for them to see it. The Utah Constitution gives them the right to be here, and to be here and not to see the evidence. What's the point of being here? We ask you to let the evidence be seen in the courtroom, please. Thank you for your time.
Thank you, counsel. Anything further as it relates to exhibits 16.1, 16.2, and 16.3 as it relates to what's been briefed or any other arguments? I just want to make sure it has all been received before the court issues its ruling.
No, thank you.
Not from the state, Your Honor. Thank you.
All right. And just to be clear, as it relates to the state's request.
Oh my gosh, nothing has happened yet. I'm going to lose my mind.
Or the three levels: admission to the court, publication to the gallery, and then publication beyond the gallery. What is the request for each of these exhibits?
We are asking. We
are asking.
Your Honor, we are asking for admission. We are asking for publication within the courtroom, but not publication electronically on to the electronic coverage in the courtroom or of these proceedings. We do want to make clear that once the exhibit is admitted, that the witness will be reading from portions of the exhibit. But then, again, we're not asking that that be displayed in any way so that those outside the courtroom could capture that and reproduce it.
Oh. Thank you. The court just wants to. And just for clarification, 16.1 is the text messages, 16.2 is Discord chats, and 16.3 is photograph of notes.
That's correct, Your Honor.
All right. And finally, and this hasn't really been addressed by any party, but it is a factor the court's weighing. How much of 16.1 has been published to the public prior to these proceedings? And this is open to all if you wish to weigh in. I just want to make sure that that's clear because that wasn't really addressed in the briefing, and it's a factor. So I want to make sure that issue has been presented by the parties, if you choose to.
Dark Schwartz Rising, there are multiple reasons. There are multiple reasons not to publish electronically. Some of it's related to the jury pool. Some of it is related to respect for the victims. They're not going to play gratuitous, repeated clips of...
Your Honor, with respect to Exhibit 16.1, some of those text messages do appear on pages 8 and 9. Pages 8 and 9 of the information that is public.
Could you give me a rough estimate or percentage of how much of the total amount of 16.1 appears not in the information? Again, I'm just trying to create a record of what is out there from your perspective so the court can consider that in its analysis.
Come on. What is happening? Why is nothing happening?
Is 18 pages total of photographs of text messages. It's approximately 5.5 pages of those 18 pages that are reproduced in the information. Thank you for your patience.
Thank you, Mr. Ballard. I appreciate you doing that on the fly. Anything further from any party? To defense?
No, thank you.
To the prosecution?
No, Your Honor, thank you.
Media?
Alfarius, no, I
Let me
did
just
not
point out to the
watch
court that in addition to the
Candace
text
Owens.
messages, I believe, I haven't seen the other
Charlie.
exhibits, but I believe that at least the note itself, which is another one of the exhibits, is also describing the information.
Thank you. Ms. Kirk's victim representative attorney.
This has not been easy, as you can imagine. And I think the family deserves to see the evidence that's been gathered in this investigation. They deserve to know what happened.
I agree.
So we urge the court to please, again, display the evidence here in the courtroom.
Thank you. Thank you to all parties. I appreciate the diligence and hard work that you've put in briefing, argument. These are important exhibits as it relates to what should be considered for, again, to be clear, these exhibits are being admitted to the court in its entirety. The question before the court is publication. It's in the courtroom and beyond the courtroom.
Thank you, bud.
And so this is the ruling as it relates to the briefing. And I know it wasn't a formal motion, but I'm just trying to be thorough in my approach. This matter comes before the court on state's request to publish Exhibits 16.1, 16.2, and 16.3 during the preliminary hearing and defendant's objection to that request. The exhibits consist of text messages between Mr. Robinson and a witness, Discord messages between Mr. Robinson and others, and a written note the state attributes to Mr. Robinson. Attorneys for Mr. Robinson argue the publication of the exhibits during the proceedings subject to electronic media coverage would create a substantial risk of prejudice and impair his rights to due process under the 14th Amendment.
How?
The defendant relies on Rideau versus Louisiana, Estes, and Skilling, and asks the court to consider any admissible exhibit for the purposes of the preliminary hearing while limiting their public display or broadcast. The state responds that Rideau...
Just for a second, I want you to... If anybody out there who's watching this, I know somebody's out there. I'm not trying to make fun of anybody. But if you're one of the people watching this and you think that showing any of this stuff, if you think that that would taint a jury, I want you to think about what it is that you think would taint a jury. Like, what thing do you think that they are bringing into court that is going to improperly sway the jury towards, well, they seem to only care about one outcome, but either outcome. What do you think the problem is with, say, publishing something to the courtroom or to be watched? Why do you think that that will taint a jury? Is it because it makes Tyler Robinson look really guilty? Because if so, that's not jury tainting, but that might be a bad sign for him. That might be an indication that things are not going to go well. And I think that's the problem that people have. People are going, well, we're looking at this evidence and we don't want people to see this because, well, it kind of makes him look guilty.
Amnesties do not require a categorical restriction here. The state argues that the exhibits are materially different from the televised custodial interrogation at issue in Rideau because they are written communications allegedly made outside law enforcement custody. The state also argues that the potential prejudice can be addressed through trial management measures, including voir dire, and that the victim representative has an interest in being present for and able to follow important criminal proceedings. The court has considered the parties' arguments, the nature of the exhibits, and the procedural posture of this preliminary hearing, the defendant's due process interest, the public nature of the criminal proceedings, and the interests asserted by the state and victim representative. On the present record, the court is not persuaded that the publication of Exhibits 16.1, 16.2, and 16.3 during the preliminary hearing creates the type of inherent or presumed prejudice that requires categorical restrictions under Rideau, Estes, and Skilling. Unlike the broadcast interrogation in Rideau, the exhibits at issue are written communications allegedly made outside police custody and are being offered in the ordinary course of a judicial proceeding. That distinction does not eliminate the possibility of prejudice, but it weighs against treating publication of the exhibits as presumptively unconstitutional. The court further finds that any potential prejudice arising from media coverage may be addressed, if necessary, through the appropriate trial procedures, including voir dire and any other measures warranted before trial. This ruling is limited to publication of the exhibits during the preliminary hearing and does not determine their admissibility at trial, and I insert, if one occurs, or foreclose any later request for relief based on a more developed record. Accordingly, the defendant's objection is overruled. As it relates to this preliminary hearing, the state may publish exhibits 16.1, 16.2,
I'm trying to
and
knock you on. I'm
16.3,
trying.
and the court is authorizing, with the exception of the third to last page on exhibit 16.1, because it contains information including a phone number and address to be redacted before publication in the courtroom. But as it relates to 16.1, because it was publicly distributed by the state, that 16.1 in its entirety may be broadcast through electronic media. That is the ruling of the court. Counsel, how would we like to proceed?
Your Honor, just to clarify the record, the state has redacted that.
Let me address this real quick. Because again, this is one of those things where I think a misunderstanding has occurred. So Sister Honda says Tyler Robinson has not confessed. They had a confession. They would have brought it a long time ago. He still hasn't even pled. Okay. Some people mix things up. I don't believe they have a confession. A confession is where someone confesses to a police officer or investigator, law enforcement. It is recorded. Typically, it is signed. It is made willingly and knowingly. What they have said that they have are admissions. Admissions are things like, I'm the person who did it, which is what Tyler Robinson allegedly seems to have. They have presented evidence of, and has been confirmed, has said to his roommate, I did. He said, you're not the one who did it, are you? And he said, I am. I am the one who did it, is what he was saying, presumably. Now, maybe that statement is like out of context and it's a response to something else. They can certainly try and make that argument. It's going to be hard, though, because that would mean Tyler Robinson would have to make that argument, because he'd have to say what he meant, what he was responding to. He would have to sit up there and present that rather than, the state, which says, no, he's saying that he did it right here. So it's not a confession. It's an admission. The other part that is maybe confusing to people is that, how do I word this? It isn't time to bring this stuff in yet, necessarily. And there could be issues with bringing certain witnesses in and stuff like that. It may be hard to get people there. You want to save it for trial, etc. They don't need to prove he's guilty yet. They don't need those admissions now, although they get at least one of those admissions through his former lover or whatever, his roommate, lover. I don't know what the fucking term is, but that happens. That does happen in this hearing in one of the days. I think this one. But they do get that admission out of them. They introduce the cell phone evidence. So they are going to introduce it. And I have to take a brief pause and say this. This is a probable cause hearing. The evidence that they have brought in the probable cause hearing is sufficient for a guilty verdict. A jury looking at the evidence presented just in the probable cause hearing would almost guaranteed go guilty. Yep. Now, to be fair, the defense has not defended. They wouldn't at a probable cause hearing. There really isn't much to do on the defense side. So, to be fair, they have not defended yet, and we don't know what their case might be. But at this point, it's only a probable cause hearing, but they have brought enough evidence for a guilty verdict. People get in their heads. They're like, oh, beyond a reasonable doubt means beyond my idea of what doubt is. That's not your idea of doubt is unreasonable. Almost always your idea of doubt is unreasonable. That's an almost universally true statement. And I know that that's like that's a self-contradictory definition, but it's true. And I don't like that either, but it is true. Almost everybody's idea of what reasonable doubt is unreasonable. It's unreasonable amounts of doubt that they're expecting the state to overcome. The state has to overcome reasonable doubt. There is no like second shooter. There is no like exploding microphone. Those are unreasonable doubts. Tyler Robinson having a slightly different colored shirt on different cameras, taking it different with different lighting and stuff like that. That's not reasonable levels of doubt. Like that, you're talking about something that isn't a real thing. You're talking about, oh, well, this shirt in this frame, it's a different color than the other one. It's like, well, they're actually the same shirt. The lighting's just massively different between these two cameras. It's a different distances, et cetera, et cetera, et cetera. Like the level of doubt has to be reasonable, and people are going to get blown out on this one. I don't know how to tell you. This guy's going to prison forever or getting killed by the state. Like that's going to happen.
Portion we anticipated that needed to be redacted in 16.1, so we have redacted that portion. We believe that the best way to proceed now is we have.
Oh, wait a minute. I gotta. Dark Schwartz Rising says, even though it wasn't a super chat, thanks for answering my question earlier. Hey, thanks for making up for your freebie. I appreciate it. Winston Smith says, all that arguing in dead air for a decision he wrote out the night before and read into the record. I know, what a waste. But judges usually make their decisions. They only rarely change their mind. They may have a question or two that needs to get resolved to confirm it, but they usually don't.
The edited video ready that comports with the additional edits that the court
waiting
has
for them
ordered.
to decide all the time.
We propose that we
It'd be
take a break
horrible.
so that we can show that to the defense, make sure we're on the same page, and then we anticipate coming back and playing Exhibit 16.
All right. Okay. All right. I appreciate the caution being exercised by all parties. We'll take a 15-minute break. Come back at 10:50. Court is in a brief recess. Back in session. Welcome back. Turning to the state.
I apologize, Judge. We were having computer technology issues, and we believe those have been sorted out, but we have not yet had the opportunity to show the final edited versions to the defense.
All right. Well, how much time do you need?
Just as long as it takes to show the video, so maybe 10 minutes.
All right. Well, we'll go into. Well, I want to make sure sufficient time is done to do that. I'm sorry. I didn't realize that we were at this point. We'll be in recess for.
Is Posobiec involved in the court at all, or just pontificating online? He's present. He's present. He's with the Kirk family. I don't know what you mean by is he involved at all? I mean, he's there.
10 more minutes. So by 11:05 approximately.
I talked to him in Washington, D.C.
That should work, and also we can inform the bailiff
at
as
the
soon as we're
party
done,
where I
if
was
it's at that
honored
time.
personally
So
by
ladies and
Marco
gentlemen, I apologize.
Rubio,
I thought we were ready to
apparently.
proceed. I want to be respectful of all time, everyone's time, and all
Hey,
at the same time
Daily
keep
Mail,
this
you're still fucking dumb.
hearing moving forward. So court is in a brief recess.
But I talked to Posobiec, and he told
Court
me
is back in session.
he's going to be
Noting the presence of the
with
parties,
family,
all being present.
in the courtroom.
And where we left off is we were the state was looking to confer with defense to ensure that state's exhibits 16, 16.1, 16.2, and 16.3 were shared. Ms. Hunt.
We have reviewed Exhibit 16 with defense, and it comports with the court's order. At this point, we would like to put Agent Davis back on the stand and continue with displaying that, publishing that.
All right, Agent Davis, if you'd like to come forward. I remind you, you're still under oath. If you'd like to have a seat. There should be a water bottle to your left.
No, I don't
and
think
after
he
you're
was called
situated,
as a
if you wouldn't
witness or
mind
anything
adjusting
like
that microphone and bringing it close to you so the record can pick up your testimony. Ms. Hunt, your witness.
And just for the
There's
record and the
a
court's
family.
benefit, we have made the edits that the court has ordered. We have shown them to defense. Pursuant to the timestamps that the court ordered, we wanted those to be reflected very clearly. So there are sometimes large gaps of just black, empty, silent space. When there are large gaps, we will fast forward. Some of those are short enough that we'll just let it play, if the court is okay with that, with proceeding that way.
Thank you. I appreciate giving a heads up so all parties know.
Per Deacon
what's going
Rumble
on. Thank you,
says
Ms. Hunt.
So at this time, we would move to
totally
publish
had
on the
PC
monitors
by day 2.
State's Exhibit 16.
Yeah. I
Right,
mean,
and to the media, there is a
yes.
monitor for your benefit right there next to you.
But the
For
judge
the
is
camera, there is
allowing
one,
this to go
for
full
that
on.
direction as well
that
as for the
leaves
gallery.
No doubt behind on probable cause. Lance Twiggs.
This meeting is to use your statement here instead of your testimony at a preliminary hearing. You understand that? Okay, so in order to do that, I need to place you under oath and also give you an admonition about false statements. Okay.
And a spanking.
First, you do solemnly swear or affirm that the evidence you shall give in this issue shall be the truth, the whole truth, and nothing but the truth. So help you God.
Yes.
I also need to notify you that you are notified that statements you are about to make may be presented to a magistrate or a judge in lieu of your sworn testimony at a preliminary examination. Any false statement you make and that you do not believe to be true may subject you to criminal punishment as a Class A misdemeanor. You understand that?
Yes.
It potentially could be used as for punishment as a higher offense as obstruction of justice. In addition, I just want to make sure that our recording here is clear that you've also been given a federal agreement and a state agreement granting you immunity from prosecution for materials that you discuss now. Do you understand that?
Mm-hmm.
Okay. First, I'm going to cover some of the things that you've already talked about, but to make it as part of this record. First, what's your name?
Full name with middle name or just first and last?
First and last is fine.
Okay, my name is Lance Twiggs.
And do you know Tyler Robinson?
Yes, I do.
That is a pretty gay name.
This is the same Tyler Robinson that's been charged with the shooting of Charlie Kirk?
Yes.
And would you say when you first met Tyler?
I think it was 2023. I've known him longer than that, though. That was, I think, the first time I met him in person.
Wait, what?
Okay.
Oh, did you guys meet on Discord or something?
And we described your relationship with Tyler when you first met him anyway.
When I first met him, I didn't know him super well. He was just a new roommate, so I knew he knew my friend group, and I knew he liked playing games, but that's about it when we first,
Oh, this is some great testimony so far. Gary says Tyler has shown her state of remorse. Will that affect anything? It could impact his sentencing. It remains to be seen. I hate the remorse thing because if you don't show remorse through the whole trial, the judge can tag you for it at sentencing. But but if I show remorse for something, that's kind of like an admission that I did it. So until my conviction, I don't think showing remorse is an appropriate thing, right? How can you be, if you're going to maintain your innocence, how can you be sorry for something? So I hate that. I don't think they should use remorse as a standard at all. It's also completely subjective and largely bullshit.
First moved him.
Okay.
Catch you later,
Before I go
Ryan.
on, I realized my mic was muted at the outset. Was yours on? Your microphone? Okay. I'm going to repeat those admonitions just to make sure we got recorded. Okay, so again, I place you under oath.
It's their audio that's doubled up. It's not.
Just to make a record, I'm going to do it again. You do solemnly swear that the evidence you shall give in this issue shall be the truth, the whole truth, and nothing but the truth, so help you God.
Yes.
And again, I'm going to give you the false statement admonition.
Sorry, hold on. If they're saying that it's echoing, so
I think this one's mic is
I
on.
fucking love chips and salsa so much.
Okay, you don't own my mic, but that's fine.
Oh, somebody.
Okay, so we should be good. All right.
I wish I could find my cream cheese.
Is that mic on?
yes.
Okay, great. All right. Okay, sorry about that interruption. All right, so you said when you first met you were roommates?
Yeah.
Okay. And then at some point, your relationship progressed to something more than roommates, is that right?
Mm-hmm.
When was that?
So remorse should then also count 0 towards leniency on sentencing. Yes. Correct. 100%. Why should someone two people come up and stab you in the same spot? One stabs you in each nipple. One of them says, I'm really sorry I stabbed that guy. I hope his nipple feels better later. And the other one doesn't. Are you harmed less by the guy who's sorry about stabbing your one nipple versus the other guy? Is one nipple better off than the because one guy apologized? I'm so sorry, Mr. Nipple. I didn't mean to stab you so hard. Yes, you did. You did that on purpose. Remorse doesn't make sense in criminal convictions to me. I feel really bad about my crime. No, you don't. Trust me. You feel bad that you got caught and everybody's pissed off at you or whatever. But it's like you did the thing. It's not like you were like, oops, stabbed your nipple. It's not how it went. You stabbed someone. I don't think being sorry about it is of any merit at all, personally. And it certainly, you shouldn't be further punished for not saying you're sorry soon enough. What a dumb idea. well, I was going to give you, I was going to give you 6 months in jail, but you didn't say sorry until a month ago. So you're going to get 8 months now because I don't think that you're sad enough. What a dumb fucking concept that is when you really think about it. And again, it's all made up. Everybody's lying about how sad and mad and upset and sorry they are. The judges know they're lying about it. The judges just decide when someone is sufficiently apologetic, like they have shown remorse. That's not a finding. How do you know? They said something? Who cares? It's bullshit. It's not objective. I don't like it.
I think we started dating 2 or 3 months after he moved in.
Okay. And where did you live at that time?
St. George, in an apartment complex.
And is that apartment the same place you lived on September 10th?
Yes.
When you lived there with Tyler, were you in the same room? Did you live in the same room or different rooms?
No, separate rooms.
And at that time, let's say September of 2025, what were you doing with your life? Were you working, school?
I was working. I was doing like bathtub and shower repair and stuff in new construction.
Okay. What about Tyler?
I think he was both working. I think he was working for an electrician company then, and he was also in a trade school for being a, I don't know, higher ranking electrician. I'm not sure how the trade system works for that.
Okay.
But I think he was both.
What was his typical workday like?
I think he'd leave around 7 generally and get back around 3 to 4, depending on where the job was and how long it was for the day. And then on certain days of the week during school, semesters, he would then later in the day, I think around 5 or 6, go to school. So yeah.
Okay. Let's jump to September 10th. Did he spend the night in the apartment the night of September 9th into September 10th?
Yeah, he did. Yes.
Do you know when he left the apartment on September 10th?
I don't know an exact time. I just know he left early. I heard him leaving, and he just said he had a long drive to work that day, so he was leaving early.
Okay, so early. Any guess as to what when that was?
Little bit of
I don't know. I would have thought it was 5 a.m. because that's when an early work day was for him, but it was probably more like 4.
Okay.
I'm going to spit out his gum just to make sure that
I can do that.
You're finish it right in front of your laptop.
Oh, here you go.
Thank you. Thank you.
Was it hard to walk the next day?
All right, so what time did you get up on September 10th?
Probably 12 to 1 p.m.
You didn't have to work that day?
No.
And did you hear from Tyler? Did he call or text you before then?
No, he sent that message in the group chat I mentioned, but he didn't message me directly at all that day.
Okay. When did you first hear from him on September 10th?
It was at 11 o'clock with that automated message.
Okay, 11 p.m.?
Yeah.
Chief Vince El Jefe, don't rub it in. There's no food trucks around me. God, I could use a fucking food truck. Or just some cream cheese. Damn it.
What about, he asks you here, remember how I was engraving bullets? Was he engraving bullets before this?
Yeah, I don't remember exactly when, but he had said he was planning to go hunting with his family. And he asked me for if we had a Dremel, because he said he wanted to engrave messages on bullets. And I just told him where Dremel was, and I told him to make sure he doesn't set off a bullet on accident in the house. But I didn't really think about it until then.
How long before September 10th was this that he asked about the Dremel?
I don't remember, because he'd been talking about the hunting/camping trip for a couple months, but I don't remember when he was specifically asking to engrave the bullets. So
are we talking a year before?
Oh,
I should get farther away from the
It would have
mic,
been, I'd say at most a month before this
mic.
was when he was asking.
Okay.
Nick Starrow. Hey, what's up, buddy?
Right. You talked about the note that he left. I want to bring this up, and I should say that these text messages that we've been looking at here are Bates number 54. Okay, the notes have been titled 16.3 with a note, and this is Bates number 58. Do you recognize that on the screen there?
Yeah.
What do you recognize it as?
That was the note under his keyboard that he was referring to in the first text of that chain.
Okay, so where did you find this?
On his desk underneath his computer keyboard.
And I assume you read it?
Yeah.
And then what did you do with it after you read it?
I believe I just put it back down on the desk after I took a picture of it.
This is good.
And again, the time you read it was probably around 11 o'clock or so on the 10th.
Yes.
The night of September 10th.
Mm-hmm.
Right. And did you ever see that again after you placed it back on his desk?
No, I don't think I did.
And that was a desk in his bedroom?
Yes.
And that's a separate bedroom than your bedroom?
Yeah.
And now I want to go to what's been titled 16.2.
What are you going to do?
And
I'm just going to
do
be
you
engraving
recognize
messages on my
the series of messages
bullets.
here?
Hey, that's weird, buddy. Don't shoot
Yeah,
him off
that
in
was
the
the
house. What, he
server
talks
of,
like
his
his
friends
mom?
that I was mentioning.
What a,
Okay,
what a
and this is your
fucking
phone again?
strange interaction when you
yeah.
really think about that one.
And I'm assuming you recognize it because of the big crack up at the top.
Mm-hmm.
And so this is a server. Is this Discord?
Yeah, this is Discord.
Oh, I
And
knew it.
Who are members of this server? I don't want names, just generally. Who are these people?
This is his friend group. They play D&D together every week.
Okay. And I just want to scroll through this to make sure that you get a chance to take a look
What
at
did
it.
he mean?
Here, go to the next page.
Mm-hmm. Yes.
You know this fag was a druid. You know he was.
So Tyler Icom, who's that?
That's Tyler Robinson.
And these other people are just others that are members of the server?
Yes.
Judd, Barnaby, Marina, DM.
Mm-hmm.
Yes.
Yeah, like DM means Dungeon Master. So this is, these are like, most of them are names they're using in the game they're playing currently.
Got it.
Why is his name Homo
And
Fodder?
it looks like the last text from Tyler looks like it's 8 p.m. And do you know what day this would have been, 8 p.m. on the 10th or the 11th?
I would think that would be the 11th. Because at least I think so, because I don't think on the 10th that he messaged anyone before
He played
me at
his
like 11.
SD bard.
So.
That's
And he turned
just a
himself in on the
bard.
11th, right?
I thought so, yeah.
So I'm just going to go through this so that we have a record of the messages. Is that an accurate recording of that thread?
To my knowledge, yes.
And that was sent, looks like between September 10th and September 12th. Looks like the last day on this is September 12th screen.
Yes.
No filter Nat. I'm supposed to be on it this time every night. I haven't been very good at it lately.
Okay. All right, so again, those messages covered from September 10th to the evening of September 11th. Now, September 11th, what time
Of course,
did
we
you
want to
see
make sure he's not a patsy.
Tyler on
but
September
like,
11th?
Yes.
When did you first see him on September?
All right. Part of the, again, conspiracy theories are the thing that makes them persistent is that they're not falsifiable. One of the non-falsifiability goes to this idea. He was set up by some exceedingly powerful organization, like a government or a pawn shop or whatever. Okay. If their power is penetrative to this level, you're never going to get it. You know what I mean? Right? Like, what do people really think like the Jewish conspiracy is going to be uncovered by a fucking district court in Utah? Like, do you think that's going to happen? I get it. We want to make sure he's not a patsy. How do you propose to do that? I mean, a trial, right? Like, I didn't do it. These other people did it and framed me for it. Okay, cool. Show us how that happened. Otherwise, you're going to die. You'll either die soon or die late, but it'll be in prison either way. You have to have something. Like, at some point, you have to go, okay, maybe this guy just shot Charlie Kirk because he really just didn't like the way that Charlie Kirk addressed things. He thought he was a racist or a hater or whatever he thought. I don't know. But like, maybe it wasn't a conspiracy brought about by some sort of dark power. Like, maybe that didn't happen. And if it did, do you think you're going to get it out of this trial? Like, I don't know what people are expecting to happen. Like, trials don't work that way. If Tyler Robinson is found not guilty, it won't be because Tyler Robinson exposed the Jewish super conspiracy. Like, it'll just be because they presented a sufficient case to beat the guilty verdict, and that's it. There won't be like some unveiling or whatever. So I just don't know what people are thinking is going to happen, what they're looking for.
So this is the day after the shooting?
Yeah, I saw him when I woke up. Like I said, he was up and around doing a lot of stuff around the house. And then I think I saw him after that message where I said I'll come home and say I'm doing laundry, because I didn't want him going to my parents' house right then when he said there was probably cops outside. So I went back home, and it was just him there, and I said bye to him, and then he drove off. So I just went back to my parents' house.
So he acted erratically. Was he pacing?
Okay. I don't know if anybody's discussed this, but there are certain parts of the interview that they're not displaying in the courts. One of the things I just thought of, one of the reasons they might not be doing it is because that might be intimate details of a sexual relationship. And the sexual relationship, if for example, the interviewer said, how often were you guys intimate, things like that, those are not probative necessarily to the probable cause determination. So that might be why the judge is preventing some of the interview from being shown. It might be something as simple as that, getting into the private, intimate relationship might not be relevant to the probable cause hearing, even though it might become relevant at trial, and there could be a different determination then. There's different questions involved. So it could be something as simple as that too, just so we're clear.
Just sitting down, relaxing?
No, he was walking around a lot.
And that's within the home?
Mm-hmm.
And did he talk about what he had done?
Didn't go into detail. I just asked him in person if what he said was true the night before, and he said it was. He started crying a little bit and said he wishes he hadn't done it, and then kept going around and just doing stuff, I think, to keep himself busy or distracted or something.
Okay. Did he talk about what he was going to do next?
Wow! Raguso going straight for it. Well, we have confirmed homosexuality because he did report that he was standing around crying, saying, I wish I didn't do it. But there you have an admission right there. I wish I didn't do it. I wish I didn't do that. Now, of course, this is only what the one person says that he said. And so you at trial would have a credibility determination on this boyfriend or whatever. I don't know what it is. On this trans friend. But at present, at the probable cause stage, you don't really have, there's no need to go back and forth. He says that that's what he said, and that's what he said for the purposes of this hearing.
And then eventually he said that he would talk to his parents or turn himself over.
Okay. And when you left, was that how you left understanding he was going to turn himself in or go to his parents' house?
Yeah, and I didn't really want to be at our apartment while any of that was happening, regardless of what went down.
Okay. Okay, before he came home, had you seen the press releases, any of the media on this?
I'd seen one Instagram link a friend of mine had sent in our group chat, but I hadn't really looked into it at all.
And had you seen the images that were released of the suspect?
I did the next day. I don't think I saw any on the 10th.
I'm going to show you a couple of those images.
Does this guy kind of look like Paul Dano or whatever?
So, I'm on the FBI's website. You can see the URL there at the top. This is a press release about this event.
He was Clitzy
and here on the screen, you see these? Looks like there's 2 rows of 3 images.
Mm-hmm.
Do you recognize the person in these images?
I wouldn't say it with 100% certainty just because of camera quality, but that looks like him in terms of the shoes he's wearing, the sunglasses. I don't think I'd specifically seen him wearing that hat, but he was usually wearing a hat. and then jeans. So it definitely, especially the bottom, the last two, definitely do look like him. Oh, they do look like Tyler Robinson.
And you talked about that with your friends, right? This looks like him.
Yeah, his friends. Yeah, I don't know if I talked. I don't remember if I talked about it with any of my friends. And then since I had my phone after that for a while, and I still am not using social media, I don't know on my friends' end.
Okay. All right. I want to back up a little bit now. We've talked about September 10th, but let me get a little bit of context here. So, did you game with Tyler?
Yeah.
What kind of games?
We played some just kind of party games together, like anything that would be multiplayer with a group of friends. There was one game he really liked called Sea of Thieves, where you play as like a pirate, and you can fight against people, but most of it's just like fishing, fighting sharks, skeletons, kind of stuff. We played some co-op games where it's like you both have to work together to win in whatever way. Way back when, like when I was just out of high school,
identify Tyler Robinson
first knew him online. We played some like shooting games together.
No,
but
that's
I
him.
didn't know the rules, so I was just going to be like a whole friend group on to play, and he was someone that my friends invited.
Him. Okay.
Did you and he ever talk about politics?
He did more than me. I don't really keep up with politics very much. He'd usually talk about stuff he heard on the radio on his drive to work in like their work car, since it sounds like their whole crew went in the same car most of the time. But I wouldn't say super consistently, because it wasn't a topic I really contributed much on.
What about Charlie Kirk? Did he ever talk about Charlie Kirk?
I personally had never heard him talk about Charlie Kirk before specifically.
Okay. How about
what about generally?
Political issues. So did you ever talk about gender identity issues and LGBTQ rights?
No, not really. Usually if he did talk about politics stuff, it was relating to Trump or current like policies being like issued or voted on, I think. But yeah.
Okay, what did he say about him? That might be okay. There's another one, another possible thing that is not probative to whether or not there's probable cause to make the charge of Tyler Robinson. His political statements could be, especially in light of Charlie Kirk and the political nature of his, career, the political leanings and statements of the witness or of the defendant coming out, those could be prejudicial. And while I believe that if he happened to be like a suicidal, crazy communist, that might be relevant as to why he was willing to shoot Charlie Kirk, right? Like that makes sense. At the probable cause stage, though, that could, that could create an undue impression. And of course, the court would want to avoid that at all costs. So that could be another reason why some of this wasn't aired. Because if he goes on and talks about how, no, actually he was a giant socialist and he hated all capitalism like that, he goes, oh, well, maybe he is willing to shoot someone then. All commies are.
Okay, so before that you had been?
For a short time, yes.
Okay. And I understand you're going by Luna at some point?
To some people, yeah, but not as an overall thing.
Okay. I think that's all the questions I have for this portion. Let me check and see if I've missed anything. Okay. The Dremel that you talked about, you said he had asked for that, is that right? Mm-hmm. And had he told you it was to shred bullets?
Dremel up to a butt
and so did you have the Dremel then?
Yeah.
Okay.
It was in our we had our apartment. We had a section where we kept all our like random tools for household stuff in our lower basement level pantry. So yeah.
Okay. And did you give that to him or tell him where it was?
I just told him where it was. Yeah.
Tyler's Discord username was Tyler.
Okay. I'm going to go ahead and end the recording for the 1102 purposes.
Too. What was that?
All right, that concludes State's Exhibit 16. Ms. Hunt.
Thank you, Judge. Agent Davis, I asked you yesterday, but I want to remind the court and those present. Were you physically present at the interview we just watched in State's Exhibit 16?
Yes, I was there.
And aside from
Very
the
quiet chewer. I think
court-ordered
I have a noise
redactions,
gate on.
did it appear to you to be fair and accurate about what you remember that interview that day?
Yes.
It usually only picks up like the first bite.
During that interview, did Mr. Twiggs, was he shown or referenced certain items of evidence?
Yes, he was.
What types of items of evidence was he shown?
It was the text messages between himself and Tyler Robinson, Discord chat messages, and a handwritten note.
And then we also saw in the video he was also shown the FBI press release photos of the potential suspect.
That's correct, yes.
Have you reviewed all of those items as part of the investigation?
Yes, I have.
You're familiar with them?
Yes.
Right, I want to put just on the witness's screen what's been marked for identification as State's Exhibit 16.1. And for the record, this includes the edit that the one edit that the court has previously ordered.
Thank you.
Let me know when you see that on your screen.
Oh, I see it. I see it now.
Do you recognize this?
My avatar says the judge already said the cut portions are when Twiggs was asked about TR admissions. That was why the court talked about the Texas admissions case. I mean, I guess, but they discussed one of the admissions on the video, like very specifically. I mean, he said, yeah, he said he regretted doing it. Like that's an admission. So I don't know. I don't know if I believe you. I mean, I do, but I don't. I'm lamenting the absence of cream cheese, not sour cream, cream cheese. You take cream cheese and you pour salsa on it. Then you take your chip and you scoop salsa and cream cheese together. And then you put it in your mouth and you have an orgasm. That's how it goes. You should try it. God, it's great. Fuck.
Yes, I do.
What is it?
This is a photograph of screenshots of text messages between Tyler Robinson and Lance Twiggs. This is a photograph of Lance's phone.
So sorry, you said photograph. You also said screenshot. Can you differentiate or clarify there?
Yes, sorry. These are photographs directly from Lance's phone.
I'm the only one who said Israel. Yeah, I'm making a joke about people on Twitter who have said Israel. I don't think anybody in here has said Israel. Dark Schwartz Rising says cream cheese fund. I'm too poor to buy cream cheese. I need a GoFundMe for cream cheese immediately.
How do you know that?
In Lance's first interview, he's showing the FBI agents these text messages, describes them
It's
to the
not
agents.
trailer
And
park
at that time,
shit.
his phone was photographed.
And you testified, I believe, yesterday that Mr. Twiggs' first interview was the morning of September 12th, 2025. Is that correct?
That's correct, yes.
Were you physically present at that interview?
No, I was not there.
Dark
Have you
Schwartz,
spoken
there
with
isn't
the
a
officers or
DoorDash
agents that were?
Yes, I've spoken to one of those agents that was there.
in my area.
And you stated that first September 12th interview of Mr. Twiggs was recorded?
Yes, audio, video recorded.
Have you reviewed that recording?
Yes, I have.
So you stated that we're looking in State's Exhibit 16.1 at a picture of Mr. Twiggs' phone.
Yes.
Do you know who took these photos?
Yes, it was Agent Larson with FBI.
Did you speak with Agent Larson and confirm that?
I did.
Matt, isn't
And you kind of made reference to this already, but how did Mr. Twiggs initially show law enforcement the relevant text messages?
Yeah, during that first interview on September 12th,
Minnesota is
physically he shows them the phone and then allows them to photograph the phone.
And does he identify it as his phone in that interview?
Yes, he does.
Does he refer to any particular features of the phone that allows him to make that identification?
I believe the second interview he refers to the large crack in the upper left screen. So he identifies that from his second interview that was given on April 20th.
And according to your review of the recording of his first interview,
Friend of the show says, I said Patsy and you said Israel twice. Maybe I'm drawing connections that don't exist. You are. I didn't say Israel in response to you saying Patsy. I said Israel in response to that being a common accusation that's bandied about on Twitter by other people. I didn't mean to imply that it was you or anything like that. So I was just making fun of what's on Twitter. Don't worry about it.
and in speaking with the agents that were there,
Israel makes the lightning.
did he have his
That's
personal
true.
phone with him at the time
But
of the
not
September
the
12th
Thunder.
interview?
Yes, he did.
Not the Thunder. That's made in Palestine.
And was this same text thread that we're seeing in State's Exhibit 16.1 shown to him during his second interview sorry, let me get the date right, April 20th, 2026 at the Utah County Attorney's Office that we just observed part of in State's Exhibit 16?
Yes, it was shown to him.
Was he asked how Tyler Robinson is saved in his phone, like as a contact?
Yeah, just as Tyler.
Without saying it, obviously, did he identify Tyler Robinson's phone number?
Yes, he did.
Did you check
don't
the
know
number that
about
Mr.
that.
Twiggs gave as Tyler Robinson's phone number against law enforcement records?
Yes, I did.
And do they match?
Yes, they match.
Is State's Exhibit 16.1 a fair and accurate representation of the text thread between, or the relevant text thread between Mr. Twiggs and Mr. Robinson?
Yes, it is.
As part of the investigation, was a Cellbrite extraction performed on Mr. Twiggs' phone?
Yes, it was.
Did you personally review that extraction?
Yes, I have.
And according to that extraction, did Mr. Robinson and Mr. Twiggs exchange text messages on September 10th through 11th, 2025?
Yes, they did.
What time was that first text sent according to the Cellbrite extraction?
The first text was September 10th at 11 p.m.
All right, Judge, I would move to admit State's Exhibit 16.1, and then pursuant to court order, I would move to publish it to the monitors.
Mr. Novak.
We have no further objections beyond those that the court, of course, is very familiar with at this point in time.
All right, I'll note the standing objections made by defense. Those objections are overruled. This 16.1 is admitted into evidence and may be published to the gallery as well as electronically distributed through the camera.
All right, Agent, I'm not going to go through every single message, but I do want to have you read aloud certain portions of them. And I apologize to counsel, these are not actually given a page number. I have page numbers, but I'm happy to confer that we're on the same page as we go. So here we're looking at page 1 of State's Exhibit 16.1. If you could read a little more than halfway down.
I don't need anything.
Where it
just
begins Wednesday,
sneezing.
11 p.m. Will you start reading underneath that?
Yes. So this would have been from Tyler. It says, drop what you're doing, look under your keyboard.
And I apologize. Let me stop you there. How do you know that that message would have been from Tyler Robinson?
That's just, so any of the messages in gray would be from Tyler, and messages in blue would be from Lance. Just with iPhone.
Thank you.
Distinguishes the messages. And also Lance in his interview also acknowledges that, who was saying what.
And up at the top, who do we see that this thread is between?
Tyler.
All right, sorry to interrupt you. So read that again, starting from looking
So
at
what
the keyboard.
happened to your phone there, bud?
So after that, then Lance responds, he says, what? And then he says, you're joking, right? And then Tyler says, fuck, I tried to delete that.
We could scroll down to page 2.
That's not good.
And if you can continue reading along.
Okay, and Tyler says, I'm still okay, my love, but I'm stuck in Orem for a little while longer yet. Shouldn't be long until I can come home, but gotta grab my rifle still. To be honest, I had hoped to keep this secret till I died of old age. I am sorry to involve you. And then Lance replies, you weren't the one who did it, right? And Tyler says, I am, I'm sorry. Lance says, I thought they caught the person. And then Tyler says, no, they grabbed some crazy old dude and interrogated someone in similar clothing. I planned to grab my rifle from the drop point shortly after, but most of that side of town got locked down. It's quiet, almost enough to get out, but there's one vehicle lingering.
If we could scroll down to.
Okay. That is devastating. That's fucking, that's done. That's done. What's the argument going to be? I know what people are saying. They're fake messages or whatever. When they present them in court, they're going to have to present, typically they would present the actual message with the metadata that shows when it was sent, what number it was sent from to, etc. We'll have to see. But I mean, those messages are they're convicting messages. Those messages make someone they make them guilty. He could have been in a different state. He could have been in a different hemisphere. Those messages would still make a jury go, you know what? I think he maybe did it. He'd be like, no, I was on a boat in the ocean. It couldn't have been me. And they'd be like, but why'd you say that though? This motherfucker is cooked. He's done. Sledge Entertainment says cream cheese with hot sausage on mushrooms and jalapenos. It's amazing. Oh, we're in a food porn channel now. Let me tell you about chili cheese fries. Oh, yeah. We got big chunks of beef. No tomatoes on these fries.
Page 3. Continue reading.
And Lance says, why? And Tyler.
He thought he was going to get that shot off, kill Charlie Kirk, and then never tell anybody. I was going to carry it with me till the day I died. Okay, sure. That works really well these days.
Tyler says, why did I do it? And Lance says, yeah. Tyler says, I had enough of his hatred. Some hate can't be negotiated out. If I'm able to grab my rifle unseen, I will have left no evidence. Going to attempt to retrieve it again. Hopefully they have moved on. I haven't seen anything in the news about them finding it. We'll update you shortly. Or sorry, we'll update you by midnight. And then Lance says, all right, stay safe. How long have you been planning this?
Scroll down a little bit, please, Kimberly.
And Tyler replies, a bit over a week, I believe. I can get close to it, but there is a squad car parked right by it. I think they already swept that spot, but I don't want to chance it.
We can scroll down to page 4 and continue reading about halfway down. I'll stop you about halfway down.
This is while they were spot, but I don't want to chance it while they were parked there. If they'd found it, I imagine there would be more commotion. Again, I'm sorry for roping you into all of this. You shouldn't have to worry about this. And Lance replies, does anyone else know? Tyler says, not to my knowledge.
All right, I'll stop you there. Let's move to page 5. So this should be page 4, so just scroll down 1, please, Kimberly. And if you could read starting... sorry, Kimberly, scroll a bit more down. If you could read, I don't know, about a 1/3 of the way up that starts with guess.
Okay. Tyler says, guess I'm just sitting in my car watching reels for another hour, hoping this guy fucks off.
And continue.
And Lance says, are you okay still? And Tyler says, yes, check and spot again now. Will.
Sorry, now we're on page 6.
Let me help out with something here, too. I'm not trying to pick on you, some guy. Some goy, probably. He says, you just shot a political figure in front of the world and you immediately have to text your furry boyfriend about and admit to doing it. Galaxy brain move. Stop for a second. Stop for a second. Because what you've done is you've taken something, someone irrational, and you have put rationality upon them. You're like, why would anyone do this? I mean, who would do that? The same person who would murder Charlie Kirk. You know what most people didn't do most days was murder Charlie Kirk. In fact, pretty much all of the time existed without Charlie Kirk being murdered by someone until Tyler Robinson or the other shooter lost his mind and decided to do something extremely irrational. Now, when someone murders someone else, especially a planned out murder based on like speech, for example, you can't expect rational, logical decision-making to flow from that event. One does not simply walk into Mordor and murder Charlie Kirk and then like do everything the normal way. They're irrational. They're insane. Someone who has overcome their humanity to a sufficient purpose to kill someone, you don't go, oh, it was really weird that he sent a text message after. It was weird that he murdered that guy. Like, that's the weird thing. That's way weirder than the text message thing, is the murdering of someone over words. Like, that's the weird thing. The text message thing, it's kind of weird. But in light of the murder, it's not that strange. And it shouldn't be a big mystery that people who do something that is on... I have a real interest in the fringes of humanity, the very edge of human experience. Murdering someone is obviously on the edge of human experience. Not that I want to do all these things, but I'm interested in what brings people to that, how they process through it, how they cope with it, how they do it, what they do around it. Anytime you have someone on the edge of the human experience, anytime, and it doesn't matter what that edge is, you cannot expect rational, reasoned behavior to flow from what they're doing. You just can't. People don't know how they're going to react if like a loved one gets killed in front of them. They don't know what they're going to do. You can't be like, oh man, it was really weird how you didn't scream at all. Well, some people scream, some people don't, you know, like you don't know, you never know. And so like these sort of ideas of what should have been done, what doesn't make sense. Of course it doesn't make sense. You know what else doesn't make sense is murdering someone. with a rifle while they're talking in front of a giant audience. Like, that doesn't make any sense at all, but someone did it. And so it's important to keep that in mind when you're thinking through these things and looking at them. You cannot have an expectation of level-headed, rational decision-making when you're talking about someone who murdered a politician in front of everybody.
Are you reading?
We'll update soon. He continues, the squad car was moved further away enough that I should be able to move in. I backed off because I thought I heard footsteps, maybe a foot patrol, but the crickets here are so fucking loud. Gonna see if the road closer to campus is open so I can drive past and check shit out. Probably still closed off though. Getting worried, hard to know for sure, but I'm not finding my rifle. Could be in the wrong spot. Lance says, do you think they found it? And Tyler says, dunno, they haven't published anything if they have. And then Lance says, why did you leave it behind?
Those texts, while probably real, are suspiciously similar to what they would say if it was part of a setup. Well, you got that backwards. A setup that's well done would have texts that look reasonable. Otherwise, it wouldn't be a very good setup, right?
Oh, sorry, Kimberly, if you could scroll down.
Originally. Also, does it have a serial number?
You could scroll to page 7. And I'll continue reading. I'll stop you on this page in a little bit.
Okay. So Tyler continues, IDEK, if I had a serial number, but it wouldn't trace to me, I worry about prints. I had to leave it in a bush where I changed outfits. Didn't have the ability or time to bring it with.
And stop there, please. And then if we could go to the next page, page 8. And if you could start at the top.
Okay, so Lance says, was your change of clothes there or was that also gone? Or did you bring those with you originally? Anyway, you could replace the gun, or would he notice? And then Tyler says, only thing I left was the rifle wrapped in a towel. I'll bet that canine sniffed it out. Little snitching bastard. Replace it unlikely. I don't fully know what the gun was because it...
How weird is it that he wrapped up that rifle in the cum towel? There's DNA all over this thing. Ew, it's so crusty.
was old as shit, and Gramps did some modifying. There was a 4-digit serial on it. God only knows who it's registered to. Hopefully some dead guy who gave it to Grandpa. And he continues, remember how I was engraving bullets? The fucking messages are mostly a big meme. If I see notices bulge UWU on Fox News, I might have a stroke.
And then continue. I'll stop you in a moment.
He says, all right, I'm going to have to leave it. That really fucking sucks.
Let me stop you there. And then if we could go on to the next page, page 9. And do you see the first blue message we see on page 9? Can you start there?
Yes. So Lance says, do you need it for hunting? And Tyler says, no, my dad wanted to use a high caliber for the rifle hunt. Judging from today, I'd say Gramps' gun does just fine. IDK. I think that was a 2K scope. Lance says, geez. And then Tyler says, OMW home 3.5 hours. Lance says, drive safe. And then Tyler says, delete this exchange.
And I'll stop you right there. And then, sorry, we're on page 9. If we can scroll to page 15. And then the second grade
don't ever
message
confess to your boyfriend
on
after
page
you
15,
murder
if you
a
could start there.
Political figure.
So this is Tyler. I'm going to turn myself in willingly. One of my neighbors here is a deputy for the sheriff. We hope to keep things sort of quiet here.
And then I'll stop you there. And we can remove the exhibit from the screen. Thank you, Kimberly.
He's going to turn himself in now.
We mentioned a Cellbrite extraction of Mr. Twig's phone. Do you know what time that last text was sent?
Yeah, I recall it was just before 8 p.m. on September 11th. It was, I think, 7:42 p.m. is my recollection.
I'm sorry, September 11th?
Yes.
What, September 12th?
Optimistic Realizer says there are 5 different DNAs on the gun. However, they just talk about Lance Twiggs and Tyler Robinson. Yeah, nothing to see here. We'll have to see when the, at trial, when they present the DNA evidence. But don't get wrapped up in this. DNA evidence on a gun is it's cagey. It matters where a hand landed. It matters the conditions that the gun has been kept in. It matters a whole lot of times. That's why the trigger, the DNA on the trigger matters. You know what? There might be I don't know how much DNA they found on the trigger. For example, maybe they had 1 or 2 hits. Maybe they had 5. I don't know. Anybody who's ever pulled that trigger, their DNA is basically has a good chance of being on it. But they're going to find DNA anywhere anyone has handled that gun. That doesn't necessarily mean someone shouldered it and pulled the trigger on it. So when you say they found 5 different 5 different people's DNA on the gun, where? Were all 5 in the same place? Is it all from the same sample? Were they from different spots on the gun? Do different spots have like multiple things? Sometimes it's you have multiple DNA because you have a father and a son who have the same DNA structure or whatever. But the other reason they may not be talking about the other 3 people is they may not have a positive hit on their DNA in the database. That's a thing, right? Like they could have 5 distinct DNA donors, but only have identification matching DNA in the criminal apprehension system for 2 of them. Those other 3 are still real people, but they wouldn't have a DNA match in the system for them. So they can't really talk about them because there's nothing to say. The questions then become, is the DNA helpful? If Tyler Robinson's DNA is on that gun, even a tiny speck of it, then yes, it's helpful. Because all of the other evidence adds up to him being the guy who pulls the trigger and shoots Charlie Kirk. So if they get some DNA evidence on the gun from him, great. Now, if you think it's not sufficient, then as a defense attorney, you bring in an expert who's going to argue that, oh, no. Where they found DNA is not where you would normally find DNA of a shooter. That would be where you'd find the DNA of a poser who tries to use a gun to fish or whatever you want to, whatever kind of crazy claim you want to make. You have to do that through your expert who's got to explain away the fact that there's DNA matching the defendant on the gun that's allegedly the murder weapon. That's a big problem in every criminal case that it happens. All of them. Every single one.
Make sense? Or you're saying September 11th?
So September 11th was when he turned himself in. Okay. September 11th, yeah.
Okay, thank you.
Yeah.
All right, I'm going to show just for the witness, State's Exhibit 16.2. Let me know when you see that.
Okay, I see it.
Do you recognize this?
I do.
DNA on the gun.
What is it?
It's actually
this
the
is
Thunder.
Just more photos of Lance's phone. And these are these are the sorry, how to play a brain. Sorry, go with your question, please.
I'm just asking what it is. So you said it's a photo of Lance's phone. Do you know if that's from the same time period as the exhibit we just looked at?
Yes.
And what is it of?
DC Killing Spree says you include other matching DNA with alibis or lack of being at the scene. Right. If you have a DNA match, they could have, again, they could find, they can tell when they have a different DNA sample. Like we have 5 people's DNA on this gun, even if they can't identify the 5 people, they can tell that there's a different set of DNA from a different person. And then they can draw some conclusions from there. But if they don't have the 3 names, they don't have to, there's nothing they can do. There's no alibi or whatever, because you don't know who they are. So if there's no match, but you did say matching DNA. I just wanted to clarify that only works if you actually know who it is. And then you can obviously interview them and get an alibi, like you said.
These are the Discord messages that Lance had talked about.
How do you know that?
So Lance, in the first interview with FBI, shows the phone.
Okay. Also, let's. 3mate1 says Tyler is a fucking idiot to vent like this on text messages after murdering a political figure in a manhunt. Tyler also said he's going to come back and turn himself in to the sheriff. Why? Like, if your plan is to turn yourself in, then putting evidence about yourself into a text message thread isn't hurtful, right? That's why he doesn't mind. That would be the argument. He doesn't mind saying he did it or that he's responsible or whatever because he's planning to turn himself in. It won't be a mystery. He may have changed his mind or whatever, but that was the plan, allegedly.
Photos were taken by Agent Larson, and then these images are shown to Lance during a second interview, and he confirms that these are those same messages, and this is photos of Lance's phone.
You mentioned an Agent Larson took the photos. Do you know if he's the same agent that took the photos of this exhibit 16.2?
Yes, same agent.
And you spoke with him to confirm that?
Yes, I did.
Are you aware if Mr. Twiggs is actually part of this Discord thread?
Yes, he is a part of it. He doesn't, in this section, he doesn't reply to it, but he does state in his statement that he was part of the thread.
Does he identify whether Mr. Robinson is part of that thread?
He does.
Optimistic
And when did that happen?
realizer. I agree.
He identifies that in his first interview with the two FBI agents. And
I agree. If all this evidence is legit, which so far there's not been a successful challenge to the evidence presented so far. If this is legit, he should plead guilty. I agree, because it is sufficient for a guilty verdict. So he should plead guilty and try and save his own life. Ignore the death penalty. Maybe try and plead down to 40 years in prison so he would get out, in his 60s and have a chance to live some. Maybe that's what he'd try and do with his plea deal. I don't know. But you're right. He should be pleading, and he might, after the probable cause hearing, once the judge makes the probable cause determination, says we have probable cause here, we're going to proceed to trial, he may then at that point be motivated to plea.
then he again confirms that in his second interview.
Did Mr. Twiggs say what username on Discord Mr. Robinson used, at least with respect to this thread?
Yes, it's the Tyler/Ikum, IKUM.
And is Exhibit 16.2 a fair and accurate representation of that Discord thread?
Yes, it is.
Did law enforcement send, as part of your investigation, did law enforcement send a subpoena to Discord?
Yes, they did.
Were these messages recovered via that subpoena?
They were.
Did you review that?
Yes, I did.
And in State's Exhibit 16.2 that is before you, when is the first message from Tyler sent?
7:57 p.m.
And it says yesterday. Do you have any knowledge of what day that would have been?
Yes, this would have been September 11th.
So Tyler sends the first message that you're seeing on Exhibit 16.2, September 11th at 7:57 p.m.
Yes, that's correct.
You testified earlier that Mr. Robinson arrived at the Washington County Sheriff's Office approximately at 9 p.m. Is that right?
Yes, that's correct.
And although you weren't physically present there yet because you were flying down, how do you know that he arrived approximately around 9 p.m.?
Just based on the police reports I reviewed and then go back and look at the video and such.
Let me address this real quick. Utah has a firing squad, but the firing squad in Utah is only utilized as a backup for when the lethal injection option becomes impossible. The Utah legislature found it necessary to keep the firing squad as a backup plan because, like, sometimes, like, the manufacturers of the chemicals that are used in lethal injection, for example, sometimes the manufacturers will have a shortage or like run out. They just won't make it. And if they don't make it, then if you don't have all three chemicals for the proper chemical cocktail, for example, you can't do the lethal injection. Or if one of the chemicals in the cocktail is challenged as a violation of the Eighth Amendment, cruel and unusual punishment, and a court determines that that chemical can no longer be used, which stalls up all the executions that we need to have happen. In Utah, when that happens, when the manufacturer plugs up the system and prevents the executions, firing squad is the backup. But it is the only state in the union that uses firing squad, I believe. And it's important to note that it is only a backup choice. It is not the primary choice. The primary choice is still lethal injection.
Judge, the state moves to admit State's Exhibit 16.2 and publish it pursuant to court order.
Mr. Novak. Thank you. We've already lodged all of our objections on all three phases.
All right. Noting the objections, standing objections by defense. State's Exhibit 16.2 is admitted into evidence and may be published only in the gallery, not for distribution on electronic media.
What would you guys choose? What's your choice? If you have to be executed and it has to be a real way, it can't be like Monty Python where you just get chased by topless women until you fall into a grave and die. So you have to, which was a weird way to go. honestly. You have to go. So you got hanging, gas chamber, electric chair, lethal injection, or firing squad. I think I want the firing squad, I think. I don't want to be electrocuted. Fuck that. And yeah, I don't trust the chemicals. You know, the fact that they give you a paralytic doesn't mean that you're not, you know, in absolute agony as you die. Boosh, lethal injection is said to be painless. Well, except for those lethal injection recipients who don't die from it, and they report that it's absolutely fucking terrible.
In Lance's first interview with FBI, he tells them about this letter note he found under Tyler's keyboard per a text message he received. He states from 11 p.m. on September 10th. And so at that point, Lance finds this. This is the letter he finds under that keyboard.
Okay, so to clarify, Mr. Twiggs gets a text from Mr. Robinson around 11 p.m. on September 10th telling him to look under his keyboard?
Yes, correct.
And this is what Mr. Twiggs represented was underneath the keyboard?
Yes, yes.
How did law enforcement get this photograph?
So following Lance's first interview at St. George PD, his phone is recovered at that point, taken into evidence. It is downloaded, I believe it was the following day or shortly after that. The FBI transported that phone to the RCFL, which is the Regional Computer Forensic Laboratory in Salt Lake City. The phone was downloaded through Celebrite, and after that, following that download was complete, SBI received a flash drive containing that download. From there, it went to a SIAC analyst to go through that data of his phone to look for any pertinent evidence or information that may be on there. And at that point, that this image of this letter was located.
All right, I'm going to break down a few things. You mentioned,
thank you.
I just want to make sure the record's clear. You mentioned Celebrite a few times. What is Celebrite?
It's a downloading software that's commonly used by law enforcement. I don't do that myself, but it's commonly used to recover.
Important. I don't know if you heard, but there is a new Cooking with Kurt that is out. So you have just gifted 10 people access to the Cooking with Kurt brisket episode that is coming up. Oh, yeah. You guys might not have been here for the beginning of the show. You might not have been here for the beginning of the show, but the new Cooking with Kurt brisket edition, the brisket tapes have dropped. So we're going to do that. I thought about doing it tonight, but I was like, shit, I gotta tell people about this. They have to know. So it's very possible that we will do it like tomorrow. My goal is to do it this weekend. So I will try and provide sufficient notice ahead of time and get the whole thing ready so that we're all set. But I'm so pumped. I've been waiting for a fucking cooking show forever. I've been waiting.
For data to download electronic devices, particularly cell phones.
And then you mentioned SIAC. What does that mean?
It's the Statewide Information Analysis Center. It's a division within DPS. It's a fusion center. They assist law enforcement with intelligence, various intelligence information for our investigations.
You mentioned that you don't personally do Cellbrite phone extractions. Have you spoken to the law enforcement officers that performed the Cellbrite extraction on Mr. Twiggs' phone in this case?
Prepare to lose your soul.
You know he's gonna. To those individuals, RCFL, that did that. But they, that was then provided to SBI.
Did you speak with officers at SBI that have recovered this photo that we're seeing in State's Exhibit 16.3?
Yes, I have spoken with an SIAC analyst who in particular found this image. I've spoken to her personally as well.
Was Mr. Twiggs shown what's been marked as State's Exhibit 16.3 during his second interview?
Yes, he was.
And again, you were present for that.
Yes, I was there.
Is Exhibit 16.3 a fair and accurate representation of the photo law enforcement obtained from Mr. Twig's phone and that he was subsequently shown in the second interview?
Yes, it's fair and accurate.
Your Honor, the state would move to admit Exhibit 16.3 and then also publish pursuant to court order.
Mr. Novak.
Just noting the objections that have previously been made, and I think that the court's order is that it may be published in the courtroom only.
Thank you. Noting the standing objection by defense, 16.3.
Dark Schwartz
correct?
Rising.
Correct. Is admitted into evidence and may be published only in the courtroom.
Welcome.
And not be shown or videoed.
Welcome to lawyer status. Oh my goodness. All right, guys. I think, holy crap. We actually did more.
September 11th when it was released. I do.
We did more damage to this hearing than I thought. We got 2 hours of it done. I'm going to save it here. We might resume this as we go. I mean, that conversation with the roommate, guilty. They convict people on less than that all the time. All the fucking time. The amount of evidence that has come into this pretrial hearing, is more than likely sufficient to sustain, again, not just probable cause, but a guilty verdict. They will have to work really hard to get this, to keep some of this evidence out. It's not going to go well. Now, at trial, they probably will have to bring in the roommate, which that was a big thing here. Was the judge going to order the roommate to come in? And I believe that the judge, it was either yesterday or today, did order that the roommate will have to appear in person. Remember, at the beginning of the interview, it says, this is in lieu of your statement at a pre-trial hearing. So, you run into a Sixth Amendment issue if you just let him take a statement and don't make him available for trial itself. Excuse me. Because the defense will want to cross-examine him, obviously. They want to poke holes. They want to show him to be an unreliable person. They want to make him out to be the biggest liar on the fucking planet. An opportunistic liar who's received an immunity agreement from the state. They want to make him look as guilty as possible. Like maybe he's the shooter. But they have to do it without actually making the accusation. Once they make the accusation, then they have to prove it out. But if you don't make the accusation and you lead the jury into that conclusion just kind of on their own, then you don't have to prove it. That's how you create reasonable doubt. But it has to be done very delicately. Sledge Entertainment says, law-abiding citizen, Green Mile, I'd prefer something else. There you go. Let's see. All right, guys. I think it's been a nice show. It's nice to be back. I will have to I gotta go to bed. I'm falling asleep. And I'm yawning too much. I'm making you guys yawn. That's not fair. But we are going to resume we're going to be talking more about this Tyler Robinson stuff. And we've got a very special Cooking with Kurt members only stream that's going to happen. So I'm really pumped for that. Music to My Soul says, I know this is off topic, but I haven't seen much of your show before. And I just realized that you have artwork of the Zoom lawyer cat meme. I love it. Yes, I do. That lawyer cat was painted by my friend Eric Waugh, as was the Johnny Depp painting. Those were both Eric Waugh creations. He's a really great dude. Very nice. He's one of the only Canadians will fully endorse. No, he's wonderful and a very terrific artist. If you've watched any old episodes of my show, I also have a painting of a bunch of liquor bottles that was done by him as well. So, all right. Well, guys, I think we're gonna call it for tonight, and I'm gonna try and get on this this show a little bit sooner tomorrow. When I was talking earlier about wanting to stream the Tyler Robinson stuff, that was truthful, but I had completely forgotten that I would need to be I need to help drive my daughter to and from camp, and we also had some other long distance running that we needed to do. So, play the outro. Okay, I'll play the whole outro. Here we go. Let me set it up. We'll play the whole outro. Thank you guys for hanging out tonight. Make sure you make it for the member stream. Make sure you pop on back for the next irregularly scheduled stream, but hopefully we'll get some of those knocked out this weekend. All right, guys. Have a good night. Peace. Peace.
Oh, he drinks a fair bit, but you realize that it just helps get his noggin jogging along. With his glass by his side and his kids asleep tight, we'll hear some law-splaining tonight. With his microphone muted, we'll laugh at this boomer until he explains it's all part of the plan. Watch his face become redder as he becomes madder, raging at idiots from Twitter and Erlang. From the white shores of Maine to the hills of Glenlivet, there's no one who explains the law better than Nick. So pour out a glass for the ones who have passed to make the law what we have now. Oh, his lady is fair, and she handles herself with the grace of one who has borne many children. As the wife of a lawman, she makes sure that he has the time and the place to provide for them there. So pour out an Ardbeg, a Balmore, a Lafroig. The spirits flow as the ones who get unemployed. So pour out a glass for the tea post on Twitter as we hear law-splaining tonight. From the white shores of Nairn to the hills of Glenlivet, there's no one who explains the law better than Nick. So pour out a glass for the ones who have passed to make the law what we have now. Oh, the guests are all plentiful, from Dante to Drexel. They bring their perspective and spice to the mix. But the reason we're here and the one that we cheer is the one who is showcasing us his career. So pour out a glass for the tea post on Twitter as we hear law-splaining tonight. From the white shores of Nairn to the hills of Glenlivet, there's no one who explains the law better than